ಸ್ಟಾರ್ಟ್ ಡೇಟ್ ಏನೋ ಕೊಟ್ಟಿದ್ದೀನಿ. ಲಿಸ್ಟ್ ಕೊಟ್ರೆ ಅವರು ಹೇಳಿದ್ದೀನಿ ನಾನು ಆಲ್ರೆಡಿ ಹೇಳಿದ್ದೀನಿ ನಾನು ಬ್ಯಾಂಚಲ್ಲಿ ಆ ಥರ ಇದ್ರೆ ನೋಡ್ಕೊಂಡು ಪೋಸ್ಟ್ ಮಾಡ್ತಾರೆ. ಯಾಕಂದ್ರೆ ಡೇಟ್ ಕೊಟ್ಬಿಟ್ರೆ ಎಲ್ಲ ಮಿಕ್ಸ್ ಆಗಿದ್ರೆ ಹೆವಿ ಆಗುತ್ತೆ. ಇದು ಗೌರ್ಮೆಂಟ್ ಮೊದಲೊಂದು ಅಪ್ ಟು 22 ಸರ್. ಈಗ Any memos? Any adjournment? List 2, paid for, serial number 19 to 24.
Serial number 19, my lord, reporting settlement. The settlement is in the process, my lord.
Sir, 12 years already.
Yes, my lord, because there are about five matters between the parties. And everything has been, they are sorting out to settle the
How
matter.
many years you may require for settlement?
No, my lord, this matter had come up only the, it was recently, it was served on the.
Maybe, but it is pending since 12 years.
Yes, my lord, I know. My lord.
Then
Last opportunity, my lord, because we are trying to sort out all the
12
cases.
years at least during the pendency of the appeal, if.
Well,
it
after
would not be
arguing,
settled.
after arguing before this court, my lord, this court felt that it is better to settle the matter.
Again,
That's it.
you argue, I will hear and dispose of.
No, my lord, we'll final date, my lord.
Will
we'll-
not pressurize the party for a settlement.
No, but parties are doing, my lord.
Let them accept the verdicts if they are not ready to
Allah,
settle.
they are in the process, my lord, because there are 4-5 matters, that's what.
How many days you may require?
My lord, another 2 weeks, my lord, will.
That is finally,
Yes, ma'am.
no further date.
Yes, ma'am.
Either you report settlement or go on with the
Yes, ma'am.
matter. You are for the appellant?
I am for the respondent.
Who is for the appellant?
Appellant also, they have called, they asked me to submit the same.
Current counsel for the respondent submit that the parties are exploring the possibility of settling the dispute amicably. He submits that the learned counsel for the appellant has also requested him to make such submission before the court. The next paragraph, the appeal is of the year 2000.
19.
I do not find any reason to adjourn the matter. However, to afford final opportunity at the request of the parties. List finally as a last chance, either to report settlement or to address arguments. Yes, date. Up to 2 weeks, good. Yes, next.
Serial number 25, my lord, appearing for the appellant,
Admission ಇದೆ ಸರ್ ಅದು
short accommodation,
admission ಗೆ ಏನಿದೆ ಅದು ಏನದು
admission is
138.
please, my lord.
ಅಲ್ಲಿ ಏನು ಇರಲ್ಲ admission ಗೆ 4 ಮಾತು ಹೇಳಿ ಬನ್ನಿ ನೋಡೋಣ ಫೈಲ್ ತಗೊಂಡ್ ಬನ್ನಿ
Short
ಫೈಲ್ ತಗೊಂಡ್ ಬನ್ನಿ ನೋಡೋಣ you read the file first.
Please.
Next.
List one,
Serial number 24, list number 2. See, press 1 minute time. Next item. Serial number 24, list number 2.
24.
24.
24 ಅದು ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಇದೆ ಏನು ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇದೆ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಅಪಲೆಂಟ್ ಯು ಆರ್ ಫಾರ್ ದಿ ಅಪಲೆಂಟ್
Appellant.
ಪ್ಲೀಸ್ ಫಾರ್ ಟೈಮ್ ದಿ appeal is of the year 2013 and council undertakes to address his argument on the next date of hearing. Submission is placed on record list finally as the last chance. Get ready on the next date. Next.
list one, page one, non-compliance of office objection for first time, serial number 1, government advocate, 1 to 4, government.
HCG will not HCG placed for time. Next.
Serial number 5, Virupakshi,
Hmm?
For appellant, ma'am, press time, ma'am, to comply the office objection.
6
6, Syed Akbar Pasha,
2 weeks.
place time.
7, Parsham Article,
Hearing for
Yes,
appellant,
but
2 weeks.
Next.
8, Devi Prasad Shetty,
Place time.
9, Rajesha, 9, Rajesha,
Time.
each time.
Yes.
10, Sunil T,
Absent, no representation.
11, Nishit Kumar Shetty,
2 weeks time.
10 allow, place for time. 11.
12, Sushant Venkatesh Pai,
11. absent,
Appearing
no
for the petitioner, your lordship. Pray for 3 weeks' time.
Place time. Yes.
non-compliance for second time, serial number 13, Kempraju,
A week's time, madam.
Place for time. Next.
14, Kempraju,
Sir,
This
a
time.
week's time.
15, Ravishankar Shastri,
Place time.
so 16, PM Sidmalappa,
A week's of time may be granted.
Place time.
17, Rupesh Abhi,
For the
Please,
appellant, my lordship, only one objection, my lordship. Appeal is within time, my lordship.
Comply.
Condonation
comply
of
with the
delay. Course of the day I will need fund.
Yes. Next.
18, Timegoda N,
Absent, no representation.
19, Sridevi,
Pray for 2 weeks time, madam.
Place time.
20, Mayasham,
Place time.
2 weeks time alone.
21, Lurdu Mariappa,
Absent, no representation.
non-compliance for third time, serial number 22, CN Achyutamurthy,
I appear, pray for some time. please.
Why, sir, third time? ಏನು first time ಬರ್ತದೆ? Counsel for the petition appellant place for time. Appeal is of the year 2023. It is listed for the third time for compliance of office objections. Then counsel for the appellant undertake to comply with the office objection by next date of hearing. Submission is placed on record list finally. It is posted finally. Please comply with that.
Please.
Yes.
Serial number 23, Prasanna Kumar BT.
Absent, no representation. ಅದಕ್ಕೆಲ್ಲದು ಮತ್ತೆಲ್ಲ ಅದೇ same. Finally.
24, Ashwin
For the
Esaladi.
appellants in this matter, my lords, seeking 1 week time, my lords. Senior illa dieted.
Finally posted. Please comply with
Yes, ma'am.
next.
25, Anand Mutali.
Absent, no representation. Finally, ಎಲ್ಲದನ್ನು ಹಾಕ್ಬೇಕು.
26, Rakshita.
Absent, no representation. Finally.
Non-compliance for fourth time, serial number 27, Ramchandrappa DN.
Pass over.
28, Yanand.
Finally. Appearing for petitioners. Finally, sir. Finally, done. Yes, pass over. Comply with that.
29, Manmohan PN.
Maintain.
For the appellant in this case, my lords. My lords, this is regarding to the maintainability of the petition, appeal, my lords. Once we have approached this honorable court under sections 378 of CRPC, my lords. It is held not maintainable, my
Quit
lords.
and done. Quit and leave the sessions court ಗೆ go.
The appellant is a victim, my lords.
Maybe. The accused is acquitted under 447.
Please, my lords, it says which is cognizable and non-bailable, my lords. 447
Yes,
is bailable, my lords.
wait for some time. No dear. Pass over.
Serial number 30, Sanjay B.
Pass over.
31, Gopal Gowda.
Pass over.
32, B. Pramod.
Absent, no representation. Appeal of the year 2023 listed for the fourth time. ಅದೆಲ್ಲ ಹಾಕೊಳ್ಳಿ. List finally as a last chance. Next.
33, Krishnamurthy.
You know, finally as a last chance. ಎಲ್ಲ ಹಾಕೊಳ್ಳಿ. Raise the time. Posted
34,
finally, sir.
34, Anil Kumar HS.
Absent. Finally ಇಲ್ಲಲ್ಲ. Absent, no representation. ಎಲ್ಲ ಹಾಕೊಂಡು finally.
35, Shyam Sundar.
Absent, no representation. Finally as a last chance.
36, Ashwin Esaladi.
My lords, let it be posted for Monday, my lords. We'll do it by
Raise for
then.
time. Finally, finally pass over.
My lords, kindly, my lords.
Next.
37, fifth time non-compliance,
For appellant during the course of the day, I'll do that.
Rudrappa.
Pass over.
38, Harish Bandari.
Do it in the course of the day, or subsequently they have raised the objections.
Pass over.
For order, serial number 39, Government Advocate.
Finally. Pass over.
40, Jairamaya.
Kindly press time on. 1 week of time.
With copy of the appeal papers. 2020 ಯಾಕೆ ಇಷ್ಟೊಂದು? Why you are
Finish in
not
the office, ma'am.
paying PF? ಯಾವಾಗ ಲಾಸ್ಟ್ ಇದಾಗಿದೆ? 24. 2 months ಆಯ್ತು ಇನ್ನು PF ಕೊಡೋದಿಲ್ಲ.
I will finish in the office, ma'am. Right, sir.
ಆಗಸ್ಟ್ ನಲ್ಲಿ ಇದಾಗಿದೆ. Pay it today. Pass over.
41, Somshekar HL.
Pass over.
42, Prasanna Kumar P.
I appeal for the appellant, my lords. 3 days time may be granted, my lords. I'll come.
ಯಾವಾಗ ಆರ್ಡರ್ ಆಗಿದ್ದು? 7 July. September ನಲ್ಲಿ it is ordered.
My
Till
lords,
date you have not paid.
I
We are in the month of November. Pay
apologize.
it, pay it. What is
My
the
lords,
difficulty in paying?
It was ordered through CBI,
Huh.
the respondent. So
Maybe.
we have to ascertain the address. Kindly provide
All
3
these
days.
days, what you are doing? The
Sir,
order was passed 26/9/2024. Till date, you have not ascertained the address.
That's finally.
Then
my
why
lords.
this appeal is to be kept pending? I'll dismiss for default.
I apologize, my lords.
No, pass over.
43, Government. 44, Ramadevi, finally 44.
Pass over.
45, Ram Prasad.
Council prays for a week's time.
Address. ಯಾವಾಗ ಆಗಿದೆ ಆರ್ಡರ್? ಇದು 9 September. Order is of the month September. Pass over.
2 days may kindly be granted.
Sir, it is full. Please pay it. Please
46,
pay it. Next.
Government Advocate.
2 days time may be granted, but I will furnish.
Then SCCP prays for time to furnish PF. To furnish copy of the appeal and the IA. ಯಾವಾಗ ಆಗಿದೆ ಆರ್ಡರ್? As per order dated so and so, notice was ordered until date the PF is not paid, list finally of the last chance. Next,
47, Krishna Rao M.
finally. Pass over.
List 2, serial number 1, for being spoken to. George period.
Correspondent number.
ಏನಾಗಿದೆ?
There are some case numbers.
Mistake in mentioning MC number, is it?
Yes, ma'am. MC number, instead of MC, it is copy, and also in paragraph 3 and 7. it is
No,
only
first
six-
tell me which paragraph the mistakes have.
In paragraph 3.
Hmm.
Instead of MC number, it has to be OP number. In Kerala, it is
OP.
OP.
Number is correct, 2858.
No, instead of that 3 is not required. 659/2020.
No, what is this MC number 2858? That is correct. ಅದನ್ನ ಹೇಳಲ್ಲ.
ನಾನು ಹೇಳ್ತೀನಿ.
ಹಾ,
ನಾನು ಹೇಳ್ಬೋದು.
ಕೊಡಿ. Don't compel the court to look into it and make corrections. Yes, yes.
In MC number, 3659/2024 it is typed.
Hmm.
Instead of that, it is to be OP number 659/2021.
Earlier to that, MC number 2858, that is correct.
2858 is correct.
Yes, then.
Then in para 7, again, sorry, then later on para 5, instead of MC number 4659/2021.
Hmm.
OP number 659/2021. Instead of MC, this will be OP and 659.
Yes.
No. Then in paragraph 7.
Hmm.
Instead of MC number 3659/2021, it is to be
OP number 659.
659/20.
Yes.
That's all.
Then again, in the last sentence, there is a mistake.
It's only with regard to that particular number. OP number 659/20.
Heard learned counsel for the petitioner. The mistakes have crept in para numbers 3, 5, 7, 3 and 7, as suggested in the memo. Office is directed to make necessary corrections and to issue fresh, issue certificate copy afresh. Yes.
Serial number 2, Amit Deshpande.
ಏನಾಗಿದೆ? ಅದು ಮೊನ್ನೆದಾ? ಮೊನ್ನೆ ಬೇಲ್ ಆಗಿದೆ. Okay. ಏನಾಯ್ತು NBW ಏನಾಯ್ತು? ಇಶ್ಯೂ ನಾನ್ ಬೇಲಬಲ್ ವಾರಂಟ್ ಅಂತ ಆಗಿದೆ. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ಇಶ್ಯೂ NBW ಅಂತ ಇದೆಯಲ್ಲ, ನಾನ್ ರಿಸಿಟ್. Yes, what happened to the NBW serial number 2? Get information, pass over.
Serial number 3, B. Ravindra, Mohammad Tahir. Master the
Respondent has already expired. Abated.
Withdraw the.
Yes, counsel for the appellant filed a memo seeking permission to withdraw the appeal. Memo is accepted, appeal is dismissed as withdrawn. Yes.
Serial number 4, Manjunatha H.A. H.A. Manjunatha.
Sole respondent. Learned counsel for the appellant and respondent are absent, no representation. Police report received stating that the respondent Chandra Reddy expired on 27/2/2022. Death certificate is enclosed with the report. Hence appeal is dismissed as abated.
Serial number 5, B.S. Sachin.
NBW. Pass over. Huh? Yes.
Serial number 6, Government Advocate. NBW, ma'am. This also unexecuted.
NBW against respondent not found in this address.
They need some more time, maybe reissue.
Reissue NBW. Against the respondent through the jurisdictional police. Appellant is directed to assist the police in executing the NBW. They cannot file the report stating that he is not found in the address. Take the assistance of the appellant and execute it. Okay. ಅದು ಬೇಡ, appellant ಏನು assistance ಏನು ಬೇಡ, reissue NBW. Next.
Hearing on IA, serial number 7, C.S. Hiremat.
For appellant in this case, my lord, the offence is under section 138. The learned trial magistrate has dismissed
Yes,
the.
IA1. Third learned counsel for the appellant on IA1 of 2019 seeking special leave of the court to prosecute the appeal for the reasons stated in the application affidavit ಯಾವ್ದಿದೆ ನೋಡಿ. IA1 of 2019 is allowed, leave is granted to prosecute the appeal. List for admission.
Obliged.
Call for trial court records, list for admission.
Obliged.
Next,
Serial number 8, Ravi L. Vaidya.
same. Call for beda, PCR ಬಂದಿದೆ. List for admission. IA1 of 19 is allowed. Absent. Counsel for the appellant is absent, no representation.
9, P. Vittal Shetty.
Perused IA1 of 2019. Next,
9, P. Vittal Shetty.
absent, no representation. IA1 of 2019 is filed seeking leave of the court to prosecute the appeal for the reasons stated in so and so. IA1 of 19 is allowed, leave is granted. Call for trial court records, list for admission.
Serial
Yes.
number 10, V.S. Srikante Gowda.
Case for the complainant, allowed,
Counsel for the appellant, Haki, IA2 of 19 is allowed, leave is granted.
one.
List for admission. Yes.
Serial number 11,
Can I bring it to your attention that the appellant has died? I am the GPA holder for the respondent. I'll be filing an application.
In which matter?
In this serial number 10.
10. Appellant is no more.
No more. He died last year.
File a memo,
Yes, Your Honor.
pass over. ಅದು ಬೇಡ, ಅದು ಏನು ಆದ್ರೂ ಬೇಡ, pass over.
I take information, my lord, and if at all, if it's true, I'll
Let
take.
her report it.
Yes, much all.
Next.
7, Ramesh Babu. Serial number 11,
11. Counsel for the appellant is absent, no representation. IA1 of 2022 is filed seeking leave of the court to prosecute the appeal for the reasons. So, IA is allowed, Call for trial court records, list for admission. Next.
Serial number 12, Sunil Kumar S. 572.
Appearing for the appellant, my lords.
There is inordinate delay.
My lords, 572 days of a delay, my lords. Because I was examined as a PW1 and got marked of the documents, my lords. Again, the defendant counsel did not cross me, my lords. Again, they have filed the 311 application and it was recalled, my lords. I was unaware of it and I thought that the case was closed, my lords. So after that, I approached my counsel and
There is, the appellant filed IA1 of 2019 seeking condonation of delay of 572 days in preferring the appeal. Since the delay is inordinate, list the applications IA1 and 2 of 2019 to be heard along with the appeal, list for admission, call for trial court records, list for admission. Convince the court about the merits of the case and also the delay caused.
okay, ma'am.
Admission. Next.
Okay, ma'am.
Serial number 13, Sharan B. Tadal. 413.
Appearing for the appellant in this case, my lords.
Idu ade 413 days.
Yes.
List for admission along with the applications. Next.
Obliged.
14, Lokesh M. Y.
The appellant.
Hmm.
Delay is what is my lord.
Delay 114 days.
Yes, my lord.
No other matter. List for admission along with application.
Please, my lord.
All for trial court records, idralli 14 number.
Serial number 15, Muralidhar H. M.
Appear for the appellant. Lord's records are received.
Hmm.
The matter may kindly be posted for hearing.
No, who is the appellant?
I am the appellant.
Appellant in or state, then
Pardon me, Lord?
status in
Status is the complainant. This appeal
Complainant.
is against the acquittal.
acquittal.
Yes.
Why you are seeking stay? What is to be stayed?
They have deposited amount under 148A.
Hmm.
I am seeking stay of the release of, repayment of that amount. Since the complaint is dismissed, they have made an application seeking release of that amount, seeking recovery of that amount from the complainant. This
Recovery of
application
interim
can be
or-
heard. Pardon.
Where is the question of recovery of interim compensation?
They have made an application before the learned
That is
magistrate.
for withdrawal, not recovery.
Withdrawal means I have withdrawn that money.
You have already withdrawn.
Yeah, I have already withdrawn that money. And the complaint is dismissed on the ground that I have not reported my employer as required under KCSR. I am a railway employee.
Right.
The transaction is between,
Sir, they have moved the trial court. for
they have moved
recovery.
the trial court.
Application is filed.
Yep, application is filed. That is why I am before my lords.
When will you address the argument?
Next week only, my lords.
Next week, get ready.
Yes.
Yes. Learned counsel for the appellant and respondent undertake to address the arguments on merits. Hence, list for admission along with IA2 of 2024.
Please.
Trial court records are already received.
Received.
Please address the argument.
Yes, my lords.
Serial number 16, Gopal Krishna B. N.
Appear for appellant. Is delay of
337 days. List for admission along with application. There is inordinate delay. Call for trial court records.
17,
Appear for appellant, your lordship.
This is also 867 days
Yes, lordship. The delay may be condoned, your lordship.
delay. Call for trial court record list for admission. Along with
No-
the IA.
Notice.
Notice illa. First, convince the court.
Much obliged.
number 18,
Please put on.
Date, lord.
18, Keshav Murthy.
For the petition.
Yes.
Vishal Raghu.
My lords, this petition is for quashing of the charge sheet by virtue of a judgment and decree in
Hmm.
Guardian Lordship Act, decreed on 30/10/2020.
What was decreed?
Sorry, my lord,
This petition is for quashing
quashing of the
criminal proceedings.
proceedings.
What is the urgency?
An understanding was reached, and the urgency is that the petitioner has to go abroad. His passport
Hence, and the counsel for the respondent is directed to be present before the court to address his argument. For respondent number 2. Yes, list on any day.
My lords, I think it might just take 2 minutes, my lords.
But
Reason is-
he is absent, sir. One
My lord-
opportunity I will give him day, tomorrow or day after, 2 days bit,
As your lordship.
may not be proper. Friday.
Yes, ma'am.
Friday. You also look into the matter. Or one gidiralla? Yes. Yes.
Serial number 19, Arjun. 20, for further argument, B.S. Sachin, K. Srihari.
ಏನಿದು? You know what is this matter?
Lord,
In 138.
138. Lord,
Service of notice.
Service of notice, and thereafter, my lords had told that matter may be remanded so that the check which I have produced, my lords, may be thoroughly viewed by the trial court after summing of that check. ma'am.
Now what is to be why it is to be remanded?
My lords, the check which I have produced, my lords, on the last occasion, I have submitted, my lords, the check which I have given to the accused. The trial court, my lord, says that there is no proof of any evidence of amount which is given.
Additional document you have produced.
Additional document I have produced, my lords, of check. The check, my lords, which bears the signature of the accused also, and which is marked with the symbol where it indicates that he has withdrawn the amount by my self check. So my lords were of the view that the matter may be remanded and the check and also.
Yes. You prayed for time to inquire with the respondent. Yes. What is your instructions?
He has not signed on the check.
Yes. Then I will remand it
Please.
to the trial court.
The submission starts is that he submits the appellant contains that he has lent a loan in 2 installments. One for 2,30,000 by way of this check, my lords, and another 1,70,000 by way of cash, my lords. Even with respect to the loan, with respect to lent through cash, my lords, there is no evidence, my lord. He has not.
But at
given
least
any evidence.
this could be proved by the complainant.
Only
Yes.
with respect to this.
If
my
it is
lords,
proved, your defense regarding the
Doubtful.
availing of cash.
Please.
Because this check was not produced before the trial court, my lords. Even the defense evidence is not.
Yes. Now both of you will
Please.
have the opportunity.
Please, ma'am.
And if need be, because this is the copy of the check.
Please, we can summon
Summon
document.
the
Please, my
original.
lord, I will necessarily.
Because the signature will be disputed.
Please, my lords.
Admitted, my lords.
My lords.
That is the only ground.
My lords, no, my lords, and also the trial court, my lords, based on the that 50,000, there is one submission that 50,000 has been taken earlier and which has been repaid. Hence, there is a doubt of the transaction is the finding that has been taken by the trial court, my lords. My lords, but the whole of the amount is also, my lords, now in doubtful.
Yes.
It may be decided, my lords, wholly by the trial court after remanding.
Yes. Then bifurcate ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. How can it be bifurcated? Check amount, lending of the check amount is proved or not, for which he has now produced the copy of the check.
That is
He
only
has to prove
part-
it.
That is
He
only-
has to prove it. Yes.
Yes.
He has to prove lending of the amount with the help of the check and any other evidence.
Please.
Ask. I answer to the above point in the affirmative for the following reasons. If the contention of the complainant that the accused had availed loan of rupees 4 lakh.
Please.
4 lakh. And towards discharge of the said loan amount, he has issued the check for the said amount, which is dated 15/3/2018. The check on presentation dishonored as there was insufficient fund in the account of the accused. In spite of service of notice, legal notice, the check amount was not repaid and thereby the accused has committed the offence punishable under section 138 of NI Act. Next part. To prove the contention, the complainant examined himself as PW1 and got marked exhibit P1 to 4. The accused, after denying all the incriminating materials available on record, the accused has denied all the incriminating materials available on record, but has not laid any evidence in support of his defense. The trial court dismissed the complaint by holding that the complainant has not proved the lending of the amount. Now it is the contention of the learned counsel for the complainant that that an amount of rupees
The check amount,
2,30,000.
2,30,000.
2,30,000 was the lent through check, which was received by the accused and encashed it. So to evidence the same, he has produced copy of the check to contend that the said check bears the signature of the accused on the back side. And it evidence encashing of the self-check by the accused. However, this fact is disputed by the learned counsel for the respondent. Since the accused has not stepped into the witness box to speak about his defense, I am of the opinion that the complainant had no opportunity to cross-examine the accused and to substantiate his contention regarding lending of the amount. Therefore, I deem it appropriate to remand the matter to the trial court to enable the complainant to prove lending of the amount to the accused by needing additional evidence. It is made clear that since the appellant has produced only the copy of the check to prove his contention regarding lending of the amount, he is at liberty to summon the original check from the bank, from the bank concerned in support of his contention. Both the complainant and the accused are at liberty to lead further evidence in support of their respective contentions. The trial court is directed to consider such additional evidence and to dispose of the case in accordance with law expeditiously with the assistance by both the parties. Made clear that I have not expressed any opinion regarding sufficiency of service of legal notice on the accused. Accused, even though the learned counsel for the appellant has placed reliance on the decision of the apex court, the trial court is directed to decide the service of notice, sufficiency of service of notice on the respondent accused as well. Yes, please. Accordingly, I answer the above point in the affirmative and proceed to pass the following. Appeal is allowed. Impugned judgment of acquittal dated so-and-so, passed in so-and-so, by so-and-so, set aside. Matter is remanded back to the trial court for fresh consideration and disposal of the matter in accordance with law expeditiously with the assistance of both the parties. The complainant and the accused are at liberty to lead additional evidence as observed above. The complainant and the accused are directed to appear before the trial court on yearly.
It's any date in third week of November.
2 weeks before. 2 weeks later,
Fourth week of November. 26th,
25th,
please, ma'am.
25th November,
November,
without waiting for court notice.
please.
ಯಾವ್ದದು 20 ಅಲ್ಲ? 2 of 20, it is only a copy.
Please,
This application IA 2 of 2020,
please, ma'am.
you have produced only a Xerox copy.
Xerox copy, ma'am.
Dispose of it off. You produce.
Please, please,
you summon the
I'll summon the check, my lords,
and
and
dispose of
please,
this application.
please.
In view of disposal of the appeal, IA 2 of 2020 shall stand disposed of.
Please, ma'am. Grateful.
Next.
Figure number 21, Sampatye.
Yes, what do you say?
The Money Lenders Act. Question is whether there is implied bar under section 15 for the police to register a complaint. There is no express bar. May I take a lordship of section 15?
Yes, that was what I expressed. But since there are decisions of the coordinate bench and there is a direction to
Respect, I will
issue.
submit that it is per inquiry.
Of course.
For this reason, it's crystal clear according to me that there is no bar.
No bar, yes,
And there is no procedure prescribed for the court to take cognizance,
yes.
where under the special enactments, there is a procedure prescribed for the court to take cognizance only on a complaint. Such bar is not there under the Money Lenders Act. But what section 15 would bar is, there is no bar. What it authorizes is
Search and seizure,
search and seizure for a purpose.
yes,
There is a purpose there.
yes.
Not the registrar, the assistant registrar,
for
or any
money
officer
lender.
authorized by the state government in this way of made for the purpose, it is said that, for the purpose of
Yes, yes,
the registrar, assistant registrar, or any officer authorized by the state government in this behalf made for the purpose of verifying whether the business of money lending is carried on in accordance with the provisions of this act, enter the premises of the money lender or any person who in his opinion is carrying on the business of money lending and call upon him to produce any record or document relating to such business, and every such money lender or person shall allow such inspection and produce such record or document. Thereafter, the second provision. Second subsection.
Yes.
The registrar, assistant registrar or other officer referred to in subsection may, for the purposes of the said subsection, search the premises and seize any record or document as may be necessary. The record or document seized shall be retained only for such period as may be necessary for the purposes of examination, prosecution and other legal action. Lord, if it is found there is any crime committed, Lord, the procedure would be for
This
registration of a crime.
this procedure is to be followed by the officers suo moto, when they take suo moto action.
Yes, for the purposes of cancellation of license.
Yes,
Because he is the authority who grants the license. For the procedure to be followed under section 13 and 14. Where the authority grants license, and if it is not in accordance with law, after seizure, he would follow the procedure under 13 and 14. Now, Lord, kindly see section 41, my lord. 41. Certain offences to be cognizable.
yes,
Lord, the offences charged here is a cognizable one. And the moment it is cognizable, the police will have powers under the act to register the same as FIR, as mandated under Lalita Kumari's case. He has no choice but to register a cognizable case. unless there is a bar where the act prescribes certain procedures to take cognizance of the complaint. And if it is said that only based on a complaint by an authorized officer, the court can take cognizance. These are the facts. One,
But the state has not challenged the order of the,
that I'll have to verify. One, there is no express bar and there is no implied bar also. My lord, court cannot,
I expressed that.
yes.
See, I was also of the same opinion. There is
Yes.
no bar
Yes.
for taking cognizance.
Yes. My lord,
Since there is a decision of the coordinate bench and
That is it.
also when there is a direction for issuance of circular.
if your lordship could differ from such a
No,
finding.
if if
Refer.
I have to defer, I have to refer it to the bench.
Bench, yes, yes. Judicial discipline requires that your lordship should,
Yes.
would do
I
that. But
cannot
it's a clear case. Yeah.
I cannot dispose it.
Yes.
I will
Following
refer
that
it to the
judgment,
larger-
many other judgments have also been passed.
Maybe,
The state,
Maybe.
state
Let
has
the
not taken.
larger bench,
Yes, larger bench. Sir.
Yes.
Yes.
So good.
Section 4 of CRPC also would say CRPC, yeah. CRPC court ಅಲ್ಲಿ ಹೊಸದಾಗಿ ಕೊಡಕ್ಕೆ ಹೇಳಿ.
Yes, trial of offence under Indian Penal Code and other laws.
Other laws, unless barred by the other laws. CRPC section 4.
The petitioner being the sole accused. In CC number 7032 of 2021, pending on the file of Learned 32nd Additional Chief Metropolitan Magistrate, Bengaluru. He is seeking to quash the criminal proceedings initiated against him, arising out of crime number 131 of 2019 of RT Nagar Police Station, registered for the offence punishable under section 5 and 39 of Karnataka Moneylenders Act 1961 and section 3 and 4 of Karnataka Prohibition of Charging Exorbitant Interest Act 2004 and section 420 of IPC. The facts of the case are that the informant being the head constable of RT Nagar Police Station, on receiving credible information regarding the petitioner dealing with money lending business illegal without license and charging exorbitant interest without any authority and thereby cheating the general public and also committing the offences as stated above. Hence, he requested the police to register the case and to initiate legal action. On the basis of the first information, the FIR in crime number so and so was registered against the accused for the offences stated above. After investigation, the investigating officer filed the charge sheet against the accused. The petitioner is before this court seeking to quash the criminal proceedings initiated against him. Heard so and so. Then counsel for the petitioner mainly contended that there is a clear bar for registration of the FIR by the police and taking cognizance of the offence by the learned magistrate under both the special enactments, that is Money Lenders Act and prohibition of charging exorbitant.
Lord, the prohibition of charging exorbitant, the section 12 says application of provisions of Money Lenders Act would apply. So therefore, there is no problem.
What is that?
Section 12, my lord, of prohibition of charging exorbitant interest rate. Mutatis mutandis. It applies entirely, my lord. Section 12. So therefore, there is also no bar.
Yes. Learned counsel for the petitioner plays reliance on section 15 of the Karnataka Money Lenders Act to contend that it is only the authorized officer of the department concerned, authorized under the act, to deal with such illegal money lending. He further refers to section 5 of the Karnataka prohibition of charging exorbitant interest rate to contend that a specific procedure is contemplated under the special enactment, and the same is not followed in the present case, and therefore it vitiates the criminal proceedings now pending against him. When a counsel places reliance on the decision of the this court in criminal petition number 6409 of 2018, clubbed with the criminal petition number 5225 of 2023, disposed of vide order dated 20th March 2024, where the coordinate bench has held that the bar contemplated under section 15 of Karnataka Money Lenders Act. Section 15 of Money Lenders Act bars, which is the relevant paragraph?
Yes, para 6, my lord. Para 3, my lord, there is a decision of the coordinate bench, which is, my lord, I have initially first referred, the batch of matters. The 3-month.
1 minute. Formed an opinion that innumerable cases are coming up before this court, where the police officers, though not authorized to exercise any power under Money Lenders Act, are doing so. Accordingly, the court has issued general directions directing the Director General of Police, State of Karnataka, to issue necessary circulars or instructions to all the police officers, indicating that the police officers do not have any power, any right under the Money Lenders Act to cause search and seizure under the Money Lenders Act, or as regards a complaint filed under Money Lenders Act.
As of today, no such circulars have been issued until yesterday.
It is also held that whenever a complaint is received by the police officer, he should inform the registrar or the assistant registrar of the said complaint to enable them to take action under Money Lenders Act as is permissible under law. Placing reliance on this decision, the learned counsel for the petitioner contended that it is one more case of abuse of the authority of the police in spite of specific direction by the coordinate bench of this court. Hence, he prays for allowing the petition. Per contra, learned SPP, opposing the petition submitted that reading of section 15 of Karnataka Money Lenders Act does not bar the jurisdiction of the police in any manner. Section 15 speaks about the power of authorized officer, a specific purpose of verifying whether the business of money lending is carried on in accordance with the provisions of this act or not. Subsection 2 of section 15 also refers to the specific purpose authorizing the registrar or the assistant registrar or the other officers to search the premises and seize the records and the documents as may be necessary. And the act authorizes those officers to take necessary action for cancellation of license and in case of necessity. But this section does not in any manner bars the jurisdiction of the police to register the cognizable case, cognizable offense as provided under section 4 of CRPC. Next paragraph. Learned counsel has also contended that even section 5 of the Karnataka Prohibition of Charging Exorbitant Interest Act 2004 does not bar registration of a case by the police officer. Police officer. Learned counsel refers to section 41 of Karnataka Money Lenders Act to contend that the offense in question is a cognizable offense, and under such circumstances, the police are duty bound to register the FIR as required under the provisions of CRPC, and also in view of the directions issued by the Honorable Apex Court in Lalita Kumari. Learned SPP also contended that in view of section 12 of the Karnataka Prohibition of Charging Exorbitant Interest Act, the provisions of Karnataka Money Lenders Act 1960 is applicable mutatis mutandis to the person referred to in section 3 of this act. And therefore, it is his contention that the registration of the criminal case and the registration of the FIR on the basis of the first information in respect of a cognizable offense is perfectly in accordance with law, and therefore the petition is liable to be dismissed. Next paragraph. Learned SPP specifically contended that even though the coordinate bench of this court in Lalita Kotari, bracketnally Supra, directed the Director General of Police to issue a circular in that regard. No such circular is issued.
No, it is, the compliance report is what.
I'm sorry, the last page, they have reported the compliance one.
That
So
could-
learned SPPs are not apprised of that.
That could be recalled. That could be recalled based on this.
The order,
So,
last
I
page,
did
May
not
not
record
refer
your-
to-
this submission.
May not be true, bro.
I asked him yesterday to verify.
Yes,
that.
he verified and that's the reply we got and I made a submission, but compliance report is there.
Yes, daily order shows there is complaint.
Yes, there is compliance, compliance. You also may leave it at that and we will,
Better.
yes.
Now, what is your submission regarding this? You have not challenged this order. State has not challenged. it.
Yes, Lord, under this, now your lordship is going to refer the matter to the division bench. So therefore, it does not matter much whether we have gone to the Supreme Court or not.
No, what is his contention regarding this?
contention regarding,
How you look at the order of the coordinate bench?
my lord, as long as it is there, my lord, it is set aside. This will have to be followed.
Is it per incurium?
No, it is not per, your lordship may differ with it is not per inquiry.
ಅಲ್ಲ ಅದನ್ನ ಡಿಫರ್ ಮಾಡೋದು
Differ ಮಾಡೋದು ಅಷ್ಟೇ.
What is your contention ಅಂತ?
ಅದೇ,
Regarding validity of this order.
this order is not correct is my submission, and therefore your lordship is upholding my
As
contention.
it, while is against the provisions of.
Yes, yes. Wrong interpretation of the provisions.
Then SPP submits that. ಅದು ఏంటంటే ಅದು ಬೇಡ. Learned SPP contended that the coordinate bench of this Lalit Kothari Supra arrived at a erroneous conclusion by wrongly interpreting section 15 of Karnataka Money Lenders Act, and therefore prays for dismissal of the petition. There is the material point for consideration. My answer to the above point dash. The only point urged by the learned counsel for the petitioner and learned SPP is with regard to interpretation of section 15 and section 41 of Karnataka Money Lenders Act and section 5 and 12 of Karnataka Exorbitant Charging of Exorbitant Interest Act. The coordinate bench of this court in so and so and an opinion that the police do not have any authority to exercise the power under Money Lenders Act. And even if a complaint is received, if a complaint or an information is received, they are required to bring it to the notice of the authorized officers referred to in section 15. And they do not have any authority to register the FIR. Fair reading of section 15 of Karnataka Money Lenders Act do not convey any such meaning, but it authorizes the officer to require authorizes the registrar, assistant registrar, or any other officer authorized by the state government to verify whether for the purpose of verifying whether the business of money lending is carried on in accordance with the provisions of this provisions of the act or not. Such officers are also having the authority to search the premises, seize any records or documents as may be necessary for the purpose of examination, prosecution, or any other legal action. However, the coordinate benches of this court, however, it is stated that the coordinate benches of this court interpreted to bar the jurisdiction of the police to register the FIR under the special enactment. I find considerable force in the contention raised by the learned SPP that as per section 41 of the Karnataka Money Lenders Act, the offense is a cognizable offense, and as per section 4 of CRPC, all such offenses have to be investigated inferred and tried unless it is barred under any provision of law. Provision of law. Section 5 of the Karnataka Prohibition of Charging Exorbitant Interest Act also do not bar the jurisdiction of the police in specific words. Specific words. And section 12 makes the provisions of Karnataka Moneylenders Act applicable mutatis mutandis to the persons referred to in section 3 of the Act. Under these circumstances, I deem it appropriate to refer the matter deem it appropriate to place the matter before the Honorable Chief Justice, with a request to refer it to the larger bench to consider the position of law and to form an opinion to avoid any ambiguity in this regard. Accordingly, I formulate the following question of law. Yeah, what is the question of law to be formulated?
Lord, whether there is an express bar, express or implied bar under section 15 for the police to register a cognizable offence.
Whether there is any express or implied bar under section 15 of Karnataka Moneylenders Act or under section 5 of the Karnataka Prohibition of Charging Exorbitant Interest Act to register the FIR, to investigate into the matter
Into cognizable offence under the Act.
in respect of a cognizable offence under the special enactments. Registry is directed to place the matter before the Honorable the Chief Justice. Pass necessary orders to place the same before the larger bench for consideration. Yes.
It's obliged. Put it.
Final hearing, serial number 22, T. Ravishankar Shastri, T. A. Chandrasekhar.
For the appellant.
Have you produced the certificate copies?
Yes, ma'am.
Certificate
Along with the
copies of
memo,
Private complaint,
private complaint under 138 of NI Act, my lord,
depositions
it was produced.
produced and exhibits.
That was also.
So entire trial court record is available now.
Yes, along with memo, my lord, I have produced a certified copy.
Who is for the respondent?
Lord, proceedings under 138 of NI Act, my lord, there is an order of conviction by the learned magistrate that was reversed in the appeal, my lord, therefore complainant is in appeal.
One. PCR number 1402704.
Please, ma'am.
CC number 17438.
17438 of 06.
So trial court convicted.
Please, my lord. Check amount was rupees 2 lakhs, my lord. There was a order of conviction sentence, my lord, directing the accused to pay, my lord, sum of rupees 2 lakh.
2 lakh fine.
10,000. And my lord, out of that, 2 lakh 8,000 order to be paid to the complainant and 2,000 to the state, my lord.
How much is the compensation? 2 lakh?
8,000, my lord. Failure to, my lord, to result will, my lord, in a
Default
4 month
sentence?
default sentence, 4 months, my lord, SI.
Criminal appeal number
Lord, criminal appeal was filed, my lord,
before the sessions?
494 of 2008,
494 of
2008, my lord.
that was allowed.
That was allowed on, my lord, 25 May 2009.
Yes. What is your contention?
My lord, the learned magistrate, my lord, before the learned magistrate, my lord, complainant was examined as PW1 and produced, my lord, the documents such as check, my lord, and endorsement for dishonor of check, and, my lord, postal receipts,
Exhibit P12,
P12, P10A, my lord, P10A. That is, my lord, envelopes, 2 envelopes.
Hmm.
My lord, there was a defense on the side of the accused as DW1, and he produces, my lord, 5 documents, exhibit D1 to D6. By referring to the, please, my lord.
P1 to 6.
Yes, my lord.
No, what is your contention?
My contention was that, my lord, they both are, my lord, employed in BESCOM. Complainant and accused are both are employed in BESCOM. And, my lord, they know each other, and therefore, my lord, a hand loan of rupees 2 lakh was given to the accused for purchase of property at Gubbi. And, my lord, that was, my lord, during the year 2004. And, my lord, towards the discharge of that debt, my lord, on 6/6/2004, check was given to the complainant is the pleaded case, my lord. On presentation of that said check was, my lord, it was returned on 11/6/2004.
As
Then, my lord, a legal note, my lord, as funds insufficient.
then
And legal notice was issued on 6/7/2004, my lord.
Hmm.
Then there was it was, my lord, sent to the correct address of the accused, both the address of Gubbi and as well as the BESCOM, my lord.
Hmm.
And that was returned as refused and claimed. And therefore,
both the
yes, my lord. There was no reply then, my lord.
what is returned as refused?
Refused, then unclaimed. My lord. Refused, then not claimed. Both the endorsements were there. My lord.
So first notice is refused.
Yes,
The second one not claimed.
not claimed.
Yes.
My lord, that was referred to by the entire defense of the accused was that, my lord, when he was traveling in a bus from Naurang to Basham Circle,
Hmm.
he lost the few checks, my lord, a bag containing few checks. And that was misused by the complainant is his defense, my lord. To prove that, he produces, my lord, exhibit D4 and 5. That is the, my lord, a affidavit shown before notary, and, my lord, a police complaint.
Check is dated 6/6/2004.
Yes, my lord.
When when it was presented. On the same day.
My lord,
Endorsement is dated 12/6.
12/6/2004 is the endorsement, my lord.
Yes.
A post date a check was given, my lord, that was presented, and endorsement was on
It was a post dated check.
bank endorsement was 12/6.
No, accused had issued a post dated check.
Yes, ma'am.
When it was issued.
Returned on, my lord, 12/7/2000. 2004, 12/6/2004.
That when you lend the amount,
My lord, I said, my lord, in the year 2004.
month and date you have not.
That
shared.
was not specifically stated in the complaint, my lord.
What is exhibit D1?
My lord, the exhibit D1 was the, my lord, SSLC mass card of the accused.
Why it is produced?
In order to show his qualification, my lord, maybe. Then electricity bill showing his address, my lord. Exhibit D2 and 3. My lord, learned appellate court, my lord, mainly relies on exhibit D4 and D5, my lord, to pass an order of acquittal. That is, my lord, affidavit shown before the notary.
What is D4?
D4 is an affidavit shown before the notary. And D5 was the complaint lodged before the police station, my lord.
Regarding missing of the bag.
Bag. Now, my lord, these aspects were considered by learned.
What is the date of exhibit D4, D5?
Please, my lord. Exhibit D4, my lord, 7/1/2004.
7/1/2004.
Please, my lord.
And D5?
D5, my lord, that is dated 17/1/2004. 17/1/2004, my lord.
But it is much before presentation of the check.
Yes, ma'am. Now, my lord, these aspects were considered by learned magistrate, my lord, while passing an order of conviction. Kindly, my lord, may I take, my lord, into para 11 of the judgment of learned magistrate, my lord, at page 42, my lord. May I take from para 9 onwards, my lord, learned magistrate appreciate these documents and disbelieves these documents on the ground that, my lord, these are make-believe documents. Para 9, my lord.
1 minute. Which is the page number?
Internal page 6 of learned magistrate judgment, my lord.
No, you have produced the certificate copy.
My lord, along with the appeal memo, my lord. In the appeal memo, I have produced that.
Yes.
Para 9 onwards may I take, my lord. May I read, my lord?
Yes.
The accused has not disputed his signature on exhibit P2 check. Since the presumption under 118 and 139 of NAC is in favor of the complainant, the heavy burden is on the accused to establish that he lost the check bearing number so and so at Basham Circle while he was traveling from Navarang bus stop to Basham Circle. No doubt, the accused has got marked exhibit D5 and D4, that is complaint lodged before the Rajajinagar police station, and his affidavit to show that lost the check bearing 0099502, that is check in question, and other check leaves. In the cross-examination at page 5, DW1, that is accused, has stated that his friend one Nagaraju has promised him to get loan. Therefore, he had signed the check in question and other checks. It is pertinent to note that the accused is not a rustic villager. He is an educated man working as a lineman in Bescom. Exhibit D1 produced by the accused himself disclosed that he has completed SSLC. What made him to sign on blank checks before tender it to the somebody else is not explained by the accused. Ordinarily, no prudent man would sign the check before he tenders it to somebody else. Added to that, Exhibit D5 is only the complaint copy and Exhibit D4 is the self-serving affidavit of the accused. They are not a conclusive proof to show that the accused lost the check in question and other check leaves and other alleged materials stated in the Exhibit D5 and 4. If really he lost the check in question and other check leaves, he could have published it in the newspaper saying that he lost the check. Therefore, the Exhibit D5 and D4 are not helpful to the accused. Another main contention of the accused is that he is the permanent resident of Gayatri Nagar. Next, para 10, my lord. Next, para 10, my lord, refers to, my lord, service of notice. That may not be relevant since learned the appellate court does not, my lord, deal with this aspect, my lord. Learned magistrate holds the address stated in the affidavit as well as, my lord, in the demand notices sent are similar. And therefore, my lord, it accepts that, my lord, there was a deemed service of notice to the accused. And reply was not tendered. And thus, my lord, draws a presumption in favor of the holder of the check and, my lord, passes an order of conviction. My lord, there is a reference by the learned magistrate and appreciation of exhibit D4 and D5, my lord. Now the learned appellate court, my lord, basing upon its finding on exhibit D4 and D5, holds the exhibit D4 and D5 are much prior to the my lord, dishonor of the check. And therefore, my lord, that has to be accepted and my lord, passes an order of acquittal. Interestingly, my lord, before the learned appellate court, my lord, neither the accused nor, my lord, the complainant were heard, and there was no opportunity, my lord. Because, my lord, the criminal appeal was transferred by virtue of some notifications, and, my lord, by directing the parties to appear, my lord, the proceedings were taken up in a criminal appeal. Unfortunately, my lord, both the parties did not appear before the learned appellate court, and learned appellate court hears its own, my lord, gives a finding, and, my lord, reverses the finding. This aspect, my lord, may kindly turn to, my lord, the appellate court judgment, my lord.
Para number,
Please, my lord.
paragraph number.
Paragraph, my lord, para 4 regarding, my lord, transfer of the case. Internal page 4, my lord. At page 12, running page. May I read, my lord? This appeal was pending before the FTCS 1 as per the notification issued by the Principal City Civil and Session Judge Bangalore. It came to be transferred to this court. While transmitting the records, the said court gave a date of the parties for their appearance before the court without further notice. Hence, the fresh notice of transfer was required to be issued. The lower courts were court records have been called for when the matter was posted for argument. Both the appellant and respondent and their counsel remained absent. Since the criminal appeal cannot be dismissed for default, this court perused the entire materials on record and proceeds to pass the judgment. That is, my lord, finding, my lord. Since it's an old matter, my lord, I will not on the technicality, my lord. But, my lord, learned appellate court, my lord, bases its entire finding on exhibit D4 and D5.
Where is the discussion?
Please, my lord. Para 13, my lord, may I take, my lord. Para 12 onwards, my lord.
Yes.
The check-in question is dated 6/6/2004. As noted above, para on 7/1/2004 itself, the accused has sworn an affidavit before the notary on a stamp paper pertaining to the loss of checks, including the check-in question, and also on the same day, as per exhibit D5, the accused lodged the complaint with the police. Not only that, before that date check, 8/5/2004 itself, as per exhibit D6, the accused requested the bank to stop the payment of the lost checks. It is the contention of the accused that he was carrying signed blank checks in connection with raising of financial assistance through his friends. The accused admits that exhibit P2 pertains to his bank account and also bears his signature. But from exhibit P2, it is clear that the name of the payee, the date as well as the amount in words and figures are typed. The complainant PW1 has stated that the accused gave the check in question at Group B. The accused is serving as a lineman in BESCOM, taking into consideration of all the facts and circumstances, particularly that the date, name of the payee and the amount has been typed. The contention of the accused regarding blank check cannot be brushed aside. The accused has denied borrowing of the loans from the complainant as alleged. In the complaint at exhibit P1, it is alleged that the complainant lent hand loan to the accused by making financial assistance from his friends. Thus, as alleged in the complaint borrowed the amount from his friends and then in turn lent the same to the accused. Considering entire facts and evidence on record, the said contention of the complaint that he borrowed the loan from some other person and in turn lent it to the accused is not free from doubt. Though in the complaint, it is alleged that the complainant took financial assistance from his friends to lend hand loan to the accused. During the course of evidence, the complainant PW1 has stated that he had an amount of rupees 70,000 and he got an amount of 1,30,000 from his friends. One Nagaraj and the friend of the said Nagaraj, the said Nagaraj and the friend of his Nagaraj are not examined and no reasons are assigned. In the complaint, when the complainant lent a loan to the accused, it is not pleaded and that is also not deposed to by the complainant PW1 in his chief examination. In the cross-examination, PW1 has stated that 2 months prior to May 2003, the accused has requested to lend the loan. PW1 cross-examination has specifically stated that the check in question was given by accused in his house situated at Gubbi town in Tumkur district in the month of February or March 2004. Thus, as stated by PW1, the accused had issued the check in month of February or March 2004, but as stated by the complainant himself, 2 months earlier to May 2005, the complainant had requested to lend a loan. Hence, in the year 2004, there was no reason at all for the accused to give the check in question to the complainant for discharge of any debt or liability. It is suggested by in the cross-examination of DW1 for the complainant that the accused has borrowed a loan from the complainant to purchase the land at Gubbi. DW1 admitted in the cross-examination that he had purchased the agriculture land at Gubbi 10 years back. This statement has made by DW1 in the year 2007. Hence, as stated by him, he must have purchased the land in the year 1997. Consequently, if the suggestion of the complainant is to be believed that the accused purchased the land at Gubbi out of the loan borrowed from the complainant, lending must be in the year 1997. The complainant has not at all stated in the year 1997 he had lent the loan to the accused. At the cost of repetition, the complainant has not pleaded in the complaint when actually lent the loan to the accused. The complainant PW1 in his cross-examination has stated that while paying the amount to the accused, except the check in question, he did not obtain any document from the accused. From the statement of the complainant, it is to be said that the accused gave the check in question at the time of borrowing of the loan itself. Apart from the acts and evidence noted here in this regard, particularly when the loan was lent, further it is relevant to note that in the complaint at Exhibit P1 in 4th para, it is alleged that as agreed, accused did not pay the loan in spite of repeated request and the accused deliberately postponed on one or the other reason, and after repeated request, the accused issued a post-dated check. Thus, the facts stated by the complainant in the cross-examination as noted above that the time of borrowing loan itself, the accused gave the check in question cannot be believed. Also, may be noted here that the complainant claims that the accused has agreed to pay interest rate of 18% per annum as alleged in the complaint. However, during the course of evidence, the complaint has stated that the accused had agreed to pay the interest that the government will pay. This is inconsistent contention. Irrespective of that, the check-in question not includes the interest and to satisfactory explanation is not forthcoming from the complainant. Taking into consideration of the facts, evidence, and discussion made in the above paras, this court is of the opinion that the accused has rebutted the presumption under 139 of the Negotiable Instrument Act. When the presumption has been rebutted, then it is for the complainant to prove the debt or liability independently without relying on the presumption. In the case on hand, to prove the debt or liability, there is no other evidence except the interest statement of the complainant. Further, the said statement of PW1 is not free from doubt. Hence, this court is of the opinion that the complainant has failed to prove the debt or liability and that the check-in question was issued by the accused to the discharge of the same. So, for concern the impugned judgment in para 11, the learned magistrate has believed the case of the complaint regarding lending of 2 lakhs to the accused, though he has mentioned that the complainant had borrowed rupees 1,30,000 from his friends, etc. But the learned magistrate has not considered the inconsistency on the point and also non-examination of his friends, as well as there is no cogent evidence to when the loan was lent. Thus, it is observed that the accused has not rebutted the presumption, but the considered in the earlier paragraph by this court. In fact, the accused has rebutted the presumption. Hence, the opinion of this court, the impugned judgment is not conformity with the facts, evidence, and law. Accordingly, it is not sustainable. And my lord, consequently, My lord, here learned appellate court, my lord, I may respectfully submit, my lord, in its entirety, my lord, fails to draw the presumption available in favor of the holder of the check, my lord. My lord, it holds there are some inconsistency that he had taken loan from the friends to give the entire 2 lakhs to the accused, and that friends were not examined, and this creates a doubts and inconsistency in the statement of the complainant is the reasoning of the learned appellate court, my lord. I may respectfully submit, my lord, when there was a check which was admitted and there is no dispute regarding the, my lord, the signature found in the check, and my lord, accused has failed to, my lord, rebut the presumption, and my lord, he has failed to prove that, my lord, exhibit D4 and D5 were executed in fact. My lord, neither the notary was examined, nor, my lord, except that police complaint, a letter, my lord, nothing is placed on record, my lord, what happened to that complaint or otherwise. And in addition to this, my lord, there were admission from the hands of the DW1 regarding, my lord.
Now show me exhibit D4 to 6.
Please, my lord. Along with the memo, my lord, I have produced. At page, my lord, 37 is the D4 memo with documents, my lord. Page 37, my lord, in the memo.
Yes.
There, my lord, affidavit, exhibit D4, which speaks that, my lord, para 1. While he was traveling in BMTC bus, my lord, from Navarang to Basham Circle, he lost the bag and he noticed that he had a handbag consisted of bank passbook, checkbook, SB challan pen, and some of my land documents in Xerox copies. The checks I have lost are bearing number so and so, and the said checks were signed by me and no date, and the amount has been mentioned. What is stated above is true and correct, and this is mine. That is the affidavit shown before, my lord, a notary. Neither this notary was examined, nor notary register was marked in evidence, my lord. But the primary requirement to prove this affidavit, either examination of the notary public, my lord, at least to produce that, my lord, this affidavit was shown before the notary by producing, my lord, notary register. My lord, except this, my lord, document, nothing is placed on record to prove that exhibit D4. So far as D5 is concerned, my lord, next page I have, page 38, my lord. My lord, it speaks, my lord, about the loss of check, similar, my lord, aspect. And there is acknowledgement, my lord, just an acknowledgement stating that it was received in the police station. But there are
This
no
acknowledgement probabilizes that it was filed on 17/1/2004.
My lord, to prove this document, my lord, nothing has placed on record.
Prima facie,
Then what happened to this complaint? There is no evidence, my lord.
maybe, but
Yes,
by mere looking at exhibit D5,
yes.
prima facie, it could be presumed that the complaint was lodged with the police on 17/1/2004. It is with the signature and the seal of the police station.
Yes, my lord. My lord, may I read that document, my lord, for a moment, and I will take my lord into DW1's cross-examination, my lord.
Yes.
Lord, with reference to the above stated, I write to state that I was traveling by bus from Navarang Circle bus stand towards Basham Circle. At that,
At about
my lord, my Xerox is not
8:30 a.m.
8:30 a.m. In route number 74. When I got down at Basham Circle, to my dismay, I found that my bag containing the bank passbook, checkbooks, then challan, pan, and some of my land documents were copies of the checks I have lost is as under check number so and so. These checks were signed by me and date and amount is mentioned. That is, my lord, similar to exhibit D4, my lord, recitals. My lord, now kindly turn to, my lord, a cross-examination part of the DW1.
Come to D6, exhibit D6.
Yes, ma'am. That is 8/5/2004. My lord, after 4 months, much after 4 months from this alleged incident, my lord. The stop payment was given to these checks.
8/5,
D6, my lord.
8/5,
8/5, my lord.
2004.
8/5/2004. Whereas, my lord, this complaint and affidavit is 17/1/2004. Lord, these are my
It's also before presentation of the check.
yes, my lord, yes. Undoubtedly, my lord, how he plays tricks, my lord, he keeps this affidavit and my lord, this complaint and my lord, endorsement to the bank. My lord, at best, my lord, he would have replied to my legal notice stating about this aspect. There is no reply to my demand notices. He conveniently avoids it.
Maybe.
And my lord, now, my lord, the interesting part is these three documents, my lord, speaks about when he was traveling in a bus from Basham Circle to, my lord, Navarang to Basham Circle. While he getting down from the bus, my lord, he noticed that his bag is lost.
Yes.
Now, kindly see the cross-examination part of DW1, my lord. DW1 cross-examination part, my lord, I have produced along with the memo, my lord. Page 20, I will take, my lord.
Yes.
There, my lord, his admission is, my lord, I will skip a few sentences, my lord. There are also admission, my lord. I will read about 10 sentences from the big front side. ನಾನು ಕಳೆದ 25 ವರ್ಷಗಳಿಂದ ಬೆಸ್ಕಾಂ ಸೆಂಟ್ರಲ್ ಸಬ್ ಡಿವಿಷನ್ ರಾಜಾಜಿನಗರದಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೇನೆ. ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಗೆಟ್ ಮೈ ಲಾರ್ಡ್. ನಮ್ಮ ತಂದೆಗೆ ಹನುಮಂತರಾವ್ ಆಲಿಯಾಸ್ ಯಶವಂತರಾವ್ ಎಂದು ಕರೆಯುತ್ತಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಹನುಮಂತರಾವ್ ಎಂದು ಕರೆಯುತ್ತಾರೆ. ಸುಮಾರು 10 ವರ್ಷಗಳ ಹಿಂದೆ ಗುಬ್ಬಿಯಲ್ಲಿ ನನ್ನ ಹೆಸರಿನಲ್ಲಿ ಕೃಷಿ ಭೂಮಿ ಖರೀದಿಸಿದ್ದೆ. 2004ರಲ್ಲಿ ಫಿರ್ಯಾದಿಯಿಂದ ಪಡೆದುಕೊಂಡ 2 ಲಕ್ಷದಿಂದ ಮೇಲೆ ಹೇಳಿದ ಕೃಷಿ ಭೂಮಿಯನ್ನು ಖರೀದಿಸಿದ್ದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಮೇಲೆ ಹೇಳಿದ ಆಸ್ತಿಯ ಕ್ರಯದಾಸ್ತಾವೇಜನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಿ ಯಾವುದೇ ತೊಂದರೆ ಇಲ್ಲ. ಫಿರ್ಯಾದಿಯ ಶಿರೋನಾಮೆಯಲ್ಲಿ ಹೇಳಿದ ಕಚೇರಿಯ ವಿಳಾಸ ಸರಿ ಇದೆ. ದಟ್ ಇಸ್ ರಿಗಾರ್ಡಿಂಗ್ ಇಸ್ ಅಡ್ಮಿಷನ್ ರಿಗಾರ್ಡಿಂಗ್ ಅಡ್ರೆಸ್ ಮೆನೋಡ್. SBM ಬ್ಯಾಂಕಿನ ಪಾಸ್ಬುಕ್ ಮತ್ತು ರೆವಿನ್ಯೂ ಡಾಕ್ಯುಮೆಂಟ್ಗಳು, ಹ್ಯಾಂಡ್ ಬ್ಯಾಗು, ಪಾಸ್ಬುಕ್ ಮುಂತಾದವು ಭಾಷಂ ಸರ್ಕಲ್ನ ಬಸ್ ನಿಲ್ದಾಣದಲ್ಲಿ ಕಳೆದು ಹೋದವು. ಮೆಲೋಡ್ ಹಿಸ್ ಅಡ್ಮಿಷನ್ ಈಸ್, ಮೆಲೋಡ್ ಹೌ ಮೆಲೋಡ್ he manipulates this document, and he says in the cross examination, in the bus stand of Basham Circle, he lost these documents. Whereas, my lord, affidavit, complaint speaks, my lord, while he was traveling in a bus, he noticed and getting down from the bus, he noticed that he has lost the bag, and my lord, thus, my lord, the affidavit and police complaint were made on that day, 17/1. Whereas in the cross-examination, he says, my lord, it was lost in the bus stand. There are clear inconsistency in the evidence, and the, my lord, documentary evidence sought to be placed by him. Then, my lord, next page, my lord. Page 621 ನಲ್ಲಿ ಬಾಟಮ್ ಅಲ್ಲಿ, ಚೆಕ್ಕು ಕಳೆದು ಹೋದ ತಕ್ಷಣ ನಾನು ಬ್ಯಾಂಕಿಗೆ ದೂರು ನೀಡಿರುತ್ತೇನೆ ಎನ್ನುವುದಕ್ಕೆ ಅಷ್ಟೊಂದು ಜ್ಞಾನ ಇಲ್ಲ. ಮೆಲೋಡ page 21, ಮೆಲೋಡ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ, ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಮೇ ಫೈಂಡ್ ಇಟ್ ಫ್ರಮ್, ಬ್ಯಾಂಕಿಗೆ 2004 ಮೇ ತಿಂಗಳಲ್ಲಿ ಸ್ಟಾಪ್ ಪೇಮೆಂಟ್ ಲೆಟರ್ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಗೆಟ್ ಮೆಲೋಡ್. ನಾನು ಬ್ಯಾಂಕಿಗೆ ನೀಡಿದ ಸ್ಟಾಪ್ ಪೇಮೆಂಟ್ ಲೆಟರ್ ಅನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಿಲ್ಲ. ನಾನು ಬ್ಯಾಂಕಿಗೆ ಸ್ಟಾಪ್ ಪೇಮೆಂಟ್ ಲೆಟರ್ ಸಲ್ಲಿಸಿದ ದಿನಾಂಕ ಗೊತ್ತಿಲ್ಲ. ಆದರೆ ಬ್ಯಾಂಕ್ 8/5/4 ಬರೆದಿರುತ್ತಾರೆ. Melody, he said cross examination, he says, Melody, he has not produced. Anyway, Melody,
there is a document.
Next sentence would be relevant, Melody. ಚೆಕ್ ಕಳೆದು ಹೋದ ತಕ್ಷಣವೇ ಬ್ಯಾಂಕಿಗೆ ದೂರು ನೀಡಿರುತ್ತೇನೆ ಎನ್ನುವುದಕ್ಕೆ ಅಷ್ಟೊಂದು ಜ್ಞಾನ ಇಲ್ಲ. Melody, he, Melody, gives a police complaint. Melody, he sworn an affidavit before the notary on 17/1/2004 itself. Melody, whereas he says for giving a stop payment check to the Melody, ultimately, my lord, entire my lord case revolves upon a checks, my lord. My lord, he says for that he is not having knowledge to give stop payment instructions to the bank because he was not, my lord, well versed. Whereas he was working in a, my lord, company, Bescom company, which is, my lord, where the complaint is also working. My lord, these aspects and he
has not admitted that fact.
Which one, my lord?
Both were working in Bescom.
My lord, that is there, my lord. My lord, he has produced the electricity bill also, my lord, where, my lord, he says he was working in
Maybe,
Bescom.
but where is the cross-examination?
Please, my lord.
During cross-examination, the witness says, ಫಿರ್ಯಾದಿಯನ್ನು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಥಮ ಬಾರಿಗೆ ನೋಡುತ್ತಿದ್ದೇನೆ.
Yes.
ಅವರು ಎಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದಾರೆ ಎಂದು ಗೊತ್ತಿಲ್ಲ. Where is the cross-examination to that effect? There is not even a suggestion that you, both of you are working in BESCOM
My lord, it
and
is,
knowing each other.
my lord, it is an admitted fact, my lord. I will to show, my lord. Para 6, my lord, of his chief evidence itself. He says, my lord, the notice issued to his official address, he was shocked to receive that. Para 6, my lord.
Well, but where is the cross-examination to put your contention that both of you were working together in BESCOM? When the accused specifically stated that,
My lord, the fact remains, my lord, he admits he was working in a BESCOM.
where,
My lord, cross-examination, first line itself, page 20. I have read to my lord. ನಾನು ಕಳೆದ 25 ವರ್ಷಗಳಿಂದ ಬೆಸ್ಕಾಂನ ಸೆಂಟ್ರಲ್ ಸಬ್ ಡಿವಿಷನ್ ರಾಜಾಜಿನಗರದಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೇನೆ.
ಆಯ್ತು, accused, the complainant.
Yes, madam.
ಫಿರ್ಯಾದಿಯನ್ನು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಥಮ ಬಾರಿಗೆ ನೋಡುತ್ತಿರುತ್ತೇನೆ, ಅವರು ಎಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದಾರೆ ಎಂದು ಗೊತ್ತಿಲ್ಲ.
Yes, madam. That is he denies in his.
Where is the suggestion that the complainant is also working with him in
My lord,
BESCOM?
that suggestion he denies, my lord.
Denies ಅಲ್ಲ, ಎಲ್ಲೂ ಇಲ್ಲ. There is no such suggestion.
Now the question would be, my lord, whether, my lord, the presumption available under the NI Act is displaced by the accused, my lord, by tendering evidence. My lord, I may respectfully submit the entire documentary evidence which is sought to be placed on to rebut the presumption is Exhibit D4, D5 and D6.
Why those documents are to be disbelieved?
Yes, my lord. I may respectfully submit so far as the affidavit and the Exhibit D4 and D5 police complaints are concerned, it is not proved as required, my lord. Except producing these documents, so far as Exhibit D4 is concerned, my lord, notary was not
Exhibit D4 is to be ignored,
yes,
as notary is not examined or register is not produced.
yes.
Exhibit D5 and 6.
My lord, D5, my lord, it's a plain paper with a seal, my lord.
Maybe.
Lord, what happened to that complaint? What is the ultimate result? And my lord,
The burden on the accused is
Yes.
very less. The degree of proof is very less. It is only preponderance of probabilities, not proof beyond reasonable doubt.
yes, ma'am.
Some material prima facie, it is produced before the court.
My lord,
To
true.
show that at an undisputed point of time, a police complaint was lodged. And an undisputed point of time, stop payment instructions were issued to the bank.
My lord, I may
Why
respect.
those documents are to be disbelieved.
My lord, I may respectfully submit, my lord, these are the created documents by appreciating the evidence of DW1, my lord.
Have you suggested so in the cross-examination?
Yes, my lord.
No.
My lord, I will take. ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಹೇಳ್ತೇನೆ, ಫಿರ್ಯಾದಿ ನನಗೆ ಪರಿಚಯಸ್ಥರಿದ್ದು ಫಿರ್ಯಾದಿಗೆ ಹಣ ನೀಡಬೇಕಾಗುತ್ತದೆ ಎನ್ನುವ ಕಾರಣದಿಂದ ಅವರ ಪರಿಚಯವಿಲ್ಲ, ನನಗೆ ಸುಳ್ಳು ಎಂದು ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸ್ಟಾಪ್ ಪೇಮೆಂಟ್ ಎಂಬ ಲೆಟರ್ ನೀಡಿರುವುದು ಕೂಡ ಒಂದು ಸೃಷ್ಟಿಸಿದ್ದು, ಏಕೆಂದರೆ ನನ್ನ ಬ್ಯಾಂಕ್ ಖಾತೆಯಲ್ಲಿ ಸಾಕಷ್ಟು ಹಣ ಇಲ್ಲವೆಂದು ಬ್ಯಾಂಕ್ನವರು ಹಿಂಬರ ನೀಡುತ್ತಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. That is, my lord, suggestion made, my lord, to the DW1.
No.
And my lord, if his evidence is appreciated, my lord, he is having sufficient knowledge to give a police complaint and, my lord, to make an affidavit for the notary on 17/1/2004. My lord, he does not, my lord, give stop payment till, my lord, May. That is
Maybe, but
4
any-
months.
Before presentation, he has given it.
My lord, I may respect.
He has given it.
My lord, it's a clear act, my lord, how to, my lord, deceive a person, my lord, after giving a check, my lord, and taking money. My lord, he admits he has purchased the property at Gubbi.
Let him.
My
let
lord,
him
that is
admit.
2007. My
Now
lord,
we have to consider whether he has probabilized his defense.
yes,
He has taken a specific defense. And exhibit D5 and 6 at least, if not D4. Prima facie, it reverts the presumption.
my lord, here, if he would have taken such a defense, my lord, at the first instance itself, after receiving of a demand notice.
No,
My
that
lord,
was
it
the
would-
line of cross-examination to PW1.
PW1, my lord,
PW1.
please.
Hmm.
PW1, my lord, the cross-examination, My lord, it was nothing, my lord, a plain cross-examination, I may respectfully
Same
submit.
defense.
You see, regarding, my lord, typing of the check and interest, payment of interest. Then regarding notice, my lord, and not even a cross-examination regarding exhibit D 4, 5, and 6, my lord. No suggestion at all. He had given such a complaint at the earliest point of time, and there is a such defense was not sought to be raised in the cross-examination. ನನ್ನಿಂದ ಯಾವುದೇ ಹಣ ಕೊಂಡಿದ್ದ ಆರೋಪಿ ನೋಟಿಸ್ ನಾನೇ UCP ಮುಖಾಂತರ ಪ್ರತ್ಯುತ್ತರಿಸಿದರೆ ಸರಿಯಲ್ಲ. ನಾನು ನಿವೃತ್ತಿಯಾದ ನಂತರ ಸ್ನೇಹಿತರಿಂದ ಪಡೆದುಕೊಂಡ ಹಣವನ್ನು ವಾಪಸ್ ಮಾಡಿರುತ್ತೇನೆ. ಆರೋಪಿಯನ್ನು ತೋರಿಸಿ ಬಿಟ್ಟು ಸ್ನೇಹಿತರೆಂದರೆ ಹಣ ಪಡೆದುಕೊಂಡು ಸದುಪಯೋಗಿಸಿಕೊಂಡು ಆರೋಪಿಯ ವಿರುದ್ಧ ಸುಳ್ಳು ಪ್ರಕರಣ ದಾಖಲೆಂದರೆ ಸರಿಯಲ್ಲ. ಆರೋಪಿಯ ತಂದೆಯ ಹೆಸರು ಯಶವಂತರಾವ್ ಎಂದರೆ ನನಗೆ ಸರಿಯಾಗಿ ಗೊತ್ತಿಲ್ಲ. ಆರೋಪಿಯ ತಂದೆ ಹೆಸರು ಗೊತ್ತಿಲ್ಲದ ಕಾರಣ ಆರೋಪಿಯ ಪರಿಚಯವೇ ಇಲ್ಲ ನನಗಿಲ್ಲ ಸರಿಯಲ್ಲ. ಯಾವುದು ನಾರಾಯಣಸ್ವಾಮಿ ವಿರುದ್ಧ ಪ್ರಕರಣ ದಾಖಲಿಸಲು ಹೋಗಿ ಆರೋಪಿಯ ವಿರುದ್ಧ ಸುಳ್ಳು ದಾಖಲೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆರೋಪಿ ನನಗೆ ಹಣ ಕೊಡುವುದು ಬಾಕಿ ಇಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. No suggestion, my lord, regarding the there is not even a, my lord, suggestion regarding the D 4, 5, and 6 to PW1, and my lord, there is not even a probable defense how, my lord, this check went to the hands of the complainant, my lord. If he is a total stranger, my lord,
Yes.
my lord, to sum up, I may submit, my lord, so far as the case of the complainant is,
I understood. Our case. The complainant in CC 17438 of 2006 on the file of the Leonard 15th Additional Chief Metropolitan Magistrate, Bangalore City, is impugning the judgment dated 25th May 2009, passed in criminal appeal number 494 of 2008 on the file of 36th Additional City Civil and Sessions Judge, CCH-37 at Bengaluru, acquitting the respondent accused for the offence punishable under section 138 of an Act by setting aside the judgment of conviction, the judgment dated 24th May 2008, passed by the trial court, convicting the accused for the said offence and sentencing him to pay a fine of rupees 2,88,000 and in default to undergo simple imprisonment for a period of 4 months. The facts of the case are that parties are referred to. The complainant filed the private complaint in PCR number 14027 of 2004 against the accused, alleging commission of the offence punishable under section 138 of any Act before the trial court. It is contended by the complainant that he knew the accused very well, as both of them were employees working in BESCOM. The accused approached the complainant for a hand loan of rupees 2 lakh to meet his legal and financial necessities. He agreed to pay interest at the rate of 18% per annum and to repay the same on or before May 2004. The complainant accordingly lent an amount of rupees 2 lakh to the accused but the accused had not repaid the loan amount as agreed. Finally, he issued the check for rupees 2 lakh. Finally, after repeated demands, the accused had handed over a post-dated check bearing number 099502 dated 6/6/2004 and promised to pay the agreed interest by the end of June 2004. The check was presented for encashment. The same was dishonored as there was funds insufficient in the account of the accused. The complainant issued the legal notice to the accused notice sent through certificate of posting was duly served on the accused. But notice sent through RPD was returned unserved as was not claimed. The accused has not repaid the amount and thereby he has committed the offence punishable under section 138 of the Act. Accordingly, he requested the trial court to take cognizance of the offence and to initiate legal action. The trial court, cognizance of the offence and register, CC number 17438 of 2006. The accused appeared before the trial court and pleaded not guilty. The complainant, in order to prove his contention, examined himself as PW1, got marked exhibit P 1 to 10. The accused has denied all the incriminating materials available on record in his statement under section 313 of CRPC. He got examined himself as DW1 and got marked exhibit D1 to 6 in support of his defense. The trial court, after taking into consideration all these materials on record, convicted the accused by passing the judgment of conviction dated 24th May 2008. Being agreed by the same, the accused has preferred Criminal Appeal 494 of 08. The first appellate court, on reappreciation of the materials on record, allowed the appeal with a judgment dated 25/5/2009, set aside the impugned judgment of conviction passed by the trial court, and accordingly the accused was acquitted. Being agreed by the same, the complainant is before this court. Heard, learned counsel for the complainant. Learned counsel contended that the complainant has made a specific, raised a specific contention that the complainant and the accused were working in BESCOM and knowing each other very well. The accused requested for a hand loan, and accordingly the complainant lent an amount of ₹2 lakh during 2004 for the purpose of purchasing the land at vide. Towards repayment of the loan amount, the accused had issued the posted check. When the check was presented for encashment, it was designed as there was insufficient funds. Even though the legal notice was issued to both the addresses of the accused, they were returned answered as refused and not claimed. Therefore, it is clear that the accused was having sufficient knowledge about the contents of the legal notice, and deliberately he has not accepted the notice. When counsel submitted that the complainant has examined himself as PW1 and deposed about lending of the amount, issuance of the check, dishonor of the same, issuance of legal notice, etc. Nothing has been elicited from the witness during cross-examination. The accused, when counsel contended that the accused examined himself as DW1, an inconsistent plea was, defense was taken that he has lost his bag while traveling in the bus towards Basham Circle, and the said bag was containing signed blank checkbook with other documents, and he has logged the police complaint as per exhibit D5, sworn in affidavit as D4, and given stop payment instructions to the bank as per exhibit D6. But there is absolutely no cross-examination to PW1 on any of these documents or with regard to the defense taken by DW1. When a counsel contended that the exhibit D4 is said to be the affidavit sworn by the accused before a notary public. It is a self-serving document But swearing of the affidavit by before a notary public was never proved by the accused, either by examining the notary public or by summoning the notary register to prove swearing of the affidavit. Learned counsel also contended that exhibit D5 is a copy of the complaint said to have been lodged by the accused, except an endorsement found on the document. Nothing is placed on record to prove lodging of the complaint. It is also not stated as to what happened to the just read complaint. When it is the contention of the accused that the check which was lost was found by the complainant and he misused the same, no fresh complaint was filed against the complainant. When counsel submitted that exhibit D6 is said to be the acknowledgement for having instructed his bank to stop payment. But the check exhibit P1 was dishonored as funds insufficient, but not as payment stopped. When strangely the accused has not cross-examined PW1 in this line of defense raised at a belated stage, it is clear that exhibit D4 to 6 are concocted documents to escape from the liability. Next part. When counsel submitted that the trial court has appreciated the materials on record and arrived at a right conclusion to convict the accused, but the first appellate court committed an error in forming an opinion that the accused has rebutted the presumption, even though there is no cross-examination about on the defense taken by the accused to PW1, and even though exhibit D4 to 6 are not proved in accordance with law. Next, when counsel for the complainant submitted that the first appellate court proceeded to pass the impugned judgment without hearing the learned counsel for the appellant or the respondent, but formed such an erroneous opinion without seeking any explanation from the learned from the counsel representing the complainant. Therefore, the impugned judgment of conviction, judgment of acquittal passed by the first appellate court is liable to be set aside. Accordingly, it placed off, allowing the appeal in the interest of justice. Per contra, having dash dash empty. Which are the endorsement exhibit? Not claimed, refused. Exhibit P. P8 to 9.
P9 and 10.
Page number. P9 copy of the document, copy of the notice. No, P8 is the UCP.
Yes.
Where is refused ಇದು ಎಲ್ಲಿದೆ? ಇಲ್ಲ ರೀತಿ ಜಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಇದೆ, ಬಟ್ ಎಲ್ಲಿದೆ ಡಾಕ್ಯುಮೆಂಟ್? Unserved envelope ಎಲ್ಲಿದೆ? ಇಲ್ಲ. ಈ
Table documents I have produced, my lord.
No, P5 is there, but it is a copy of the notice. P3 is the bank endorsement.
Returned with the envelope, my lord. That envelope copies were not, my lord. But my lord, none of the magistrate refers, my lord, at internal.
No, P6 and 7 are the postal receipts. P8 is the UCP receipt. 9 and 10 are the notices. 9A and 10A are the envelopes.
There are 12 of learned magistrate.
ಅದಿರ್ಲಿ ಇಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ ನೋಡ್ತಾ ಇದೆ 9A and 9.
ನನ್ನಲ್ಲಿ ಇರೋದನ್ನ ನಾನು ಹಾಜರು ಮಾಡಿದೆ, ನನಗೆ envelope ಬಂದಿಲ್ಲ.
Sir, 9A and 10A, it is not available.
But judgment ಅಲ್ಲಿ ರೆಫರ್ ಮಾಡ್ತಾರೆ ಪ್ಯಾರಾ 12 ಅಲ್ಲಿ.
One minute. ಅದು ಗೊತ್ತು, ಅದು already you have read it.
That is covers, my lord, certified copies were not.
Next ಬರ್ಕೊಳ್ಳಿ, bullet ಹಾಕೊಂತ ಹೋಗಿ. As per the judgment of the trial court, exhibit 10 and P9A and 10A are the envelope returned unserved with the endorsement as refused and not claimed respectively. Next, the trial court has informed that the trial court records are not available as the same is already destroyed. As per the direction dated so and so previous date of hearing. Then counsel for the appellant filed the memo with the certified copies of the complaint, evidence of PW1 and DW1, exhibit P2, PP, exhibit P2, check, P3, bank endorsement, P5, copy of legal notice, 6 and 7 postal receipts, 8, let me 6 to 8 and postal receipts, 9 legal notice, 10, 9 and 10 legal notice, copy of legal notice, copy of legal notice. D1, copy of SSLC marks card of the accused. D2 and 3 electricity bills to show his address. D4, copy of the affidavit dated. It is available.
It is refused and
Covered. B. One minute. D4, affidavit dated 17/1/2004. D5, copy of the police complaint with the endorsement of the police dated 17/1/2004. Exhibit D6, copy of the letter addressed by the accused to his banker requesting to stop payment of the checks, including exhibit P1. Next. Exhibit P5 is the letter by the Senior Superintendent of Post Office, Customer Care Center, dated 21/9/2004, informing the complainant that the article referred to by the complainant, that is the notice addressed to the accused, was returned to the complainant by Gubbi Post Office with a remark refused on 14/7/2004. Prima facie exhibit D 4 to 6 probabilizes the defense taken by the accused. Even if exhibit D4 is to be disbelieved. Come on, exhibit D5 and 6. A prima facie probabilizes the defense. Next, but the accused has not received the legal notice. Prima facie it is refused or not claimed. Strangely, there is no next bullet point. Strangely, there is no cross-examination of PW1 regarding exhibit D4 to 6. On the other hand, it is suggested to PW1 that the as it is hyphenated. It is an inconsistent plea taken by the accused at the time of cross-examining PW1. Inconsistent better. It is the defense taken by the accused while cross-examining PW1. But when the accused stepped into witness box, an inconsistent plea was raised, placing reliance on exhibit D4 to 6. There is no explanation as to why such inconsistent defense was taken. Why there is no cross-examination of PW1 regarding his defense spoken to in his evidence as DW1. Order sheet. Third learned counsel for the appellant. Learned counsel for the respondent. Respondent and his counsel are absent, no representation. The appeal is of the year 2011. 13 years have already lapsed. I do not find any reason to adjourn the matter. However, to afford final opportunity to the respondent, list on. NBW issue, madam. Okay. List finally as a last chance. Sure. Yes, third learned counsel for the appellant. The respondent and his counsel absent. Finally, is posted for his evidence, his arguments. Date Kurtar.
Please.
Yes.
Serial number 23, R. Srinivas, Melan Sebastian.
So,
Serial number 24, Arjun. 25, Gurraj, K.S. Ganesh.
Hmm? First time ಬರ್ತಾ ಇದೆ ಆಮೇಲೆ okay ಆಗ್ಬೋದು.
Serial number 25, appearing for the appellant. 25.
Ah.
Lord, I seek for a
When
short
will you
account.
argue?
My lord, any date may be fixed.
Then counsel for the appellant, please for time. Appeal is of the year 2018. It is listed for admission. Counsel for the appellant undertakes to address his argument on the next date of hearing without fail. Submission is closed on record. List finally as the last chance. It is posted finally. You have to
Please,
get
ma'am.
ready and address the argument. Next.
Serial number 26, O Shiram Bhatt, Vachal.
And I am appearing for the appellant in this case.
Hmm.
Now, appellant before your lordship was the complainant before the trial court.
Yes. Trial
This-
court acquitted the accused.
Accused, respondent is the accused.
Trial court acquitted the accused.
Yes, yes. Acquittal order dated 10/1/2019,
Yes,
passed in CC number 226 of 2016.
yes. What is your contention?
My lord, my content, the case of the complainant, my lord, she has lent a sum of rupees 5 lakhs to the accused, and in turn, he had issued a post-dated check on 22/9/2015.
When it was lent?
My lord, it was lent on 20/2/2015. On that day, my lord, the date on which the amount was lent, the accused has executed a on-demand promissory note, exhibit P5.
Date is not mentioned in the complaint. It is only stated in the month of February.
Yes, it was on 20/2/2015. Exhibit P5 is the on-demand promissory note. Remember, since he has not paid the amount, and when I demanded the amount which was lent on 22/9/2015, exhibit P1, that is the check was issued,
Check for rupees
5 lakhs,
dated
29/2015, exhibit P1.
on the same day it was issued.
Same day it was issued. Remember, the check was drawn from Bank of India.
On presentation.
On presentation, it was written with with an endorsement insufficient funds.
Yes,
Therefore, on 19/10/2015, my lord, a legal notice came to be issued
yes,
on behalf of the complainant,
yes,
and it was served on the accused on 20/10/2015.
yes.
Exhibit P3 is a legal notice.
Hmm.
P3A is the acknowledgement. Sorry, P3A is the P3A is the acknowledgement for having served the notice.
P3A is the postal receipt.
Sorry,
Exhibit
postal receipt.
P4 is the.
P4
postal
is the acknowledgement. My lord, there is no reply to the legal notice. My lord, the defense of the accused, that no doubt he has taken the loan, that is for a sum of rupees 30,000. And he has issued.
Availing of the loan is admitted.
It is an admitted, but the amount is disputed.
Only
He
rupees.
says, my lord, I have taken only 30,000 amount, not 5 lakhs.
Yes,
My lord, the evidence was led in
Hmm.
on behalf of the accused, on behalf of the complaint, and accused
No, what is the
also got
defense regarding-
examined.
What is the defense regarding the check, exhibit P1 and demand
But
promissory?
that blank check was issued. That is a defense, as well as promissory note. The finding of the trial court, my lord, with regard to the capacity to lend of 5 lakhs, and there is no legally recoverable debt.
So trial court held lending of the amount is not proved.
No, the trial court has held, my lord, I have no capacity to lend 5 lakhs because I am a housewife.
Yes.
But may I take your lordship attention to?
And that is why the accused is acquitted.
Yes, ma'am.
Is there any discussion regarding the defense of the accused?
My lord, yes. Now, may I take your lordship attention to ink page number 22, paragraph number 20 of the judgment. From the aforesaid decision, it is well settled that mere proving the issuance of check by the accused is not sufficient for the complainant to prove the case. Complainant has to prove that there exists legally recoverable debt or liability against the accused. Further, in the present case, when the accused specifically taken contention that the complainant does not have a financial capacity to advance a sum of rupees 5 lakhs to the accused, it is the onus upon the complainant that she has to prove her financial capacity. During the cross-examination of the complaint, she states that her husband is a commission agent. For the purpose of his business, he used to keep the amount at the house. When he has kept 5 lakhs in their house, complainant has advanced the said amount as a loan free from interest to the accused with an assurance from the accused to repay the same within a span of 6 months. She further stated that her husband does not know about the loan transaction between the complainant and the accused. She has also not examined her husband in order to prove that he is a commission agent and used to keep huge amount of rupees 5 lakhs at home. Further, the complainant has not even produced any piece of document to show that her husband was a commission agent and was in a sound financial capacity to advance a huge amount of 5 lakhs to the accused. When the complainant herself states that she is a housewife and she does not possess any independent source of income, under such circumstances, it creates a doubt in respect of the case of the complainant that she has lent a sum of rupees 5 lakhs to the accused, and hence complaint has failed to prove that there exists a legally recoverable debt payable by the accused to her. Further, the complainant, except the oral testimony of her own, she failed to establish the accused has borrowed a sum of rupees 5 lakhs from her, and at that time, accused has executed on-demand promissory note, which is at exhibit P5. Complainant has not ventured to examine the witness, that is Ravi Kumar, who, according to the complaint, during her cross-examination, has alleged to have signed exhibit P5 on her behalf, on behalf of the complainant. Therefore, upon the consideration of the testimony of the complainant and the accused and backdrop of the various decisions relied upon by the accused counsel, it could be concluded that position of law which emerges from the decision is that it is not necessary for the accused to disprove the existence of consideration by way of direct evidence. Inference of preponderance and probabilities can be drawn by the accused by raising a probable defense from the materials brought on record by him. So also the complainant himself. Though it is obligatory on the court to raise a presumption contemplated under section 118, 138 and 139 of every case, in every case, what is needed for the accused is to raise the probable defense or that of consideration does not exist. The presumption could be rebutted either by leading evidence or bringing the facts on record in cross-examination of the complainant, showing that it is improbable that the check was issued in discharge of any debt or the other liability. If some materials is brought on record consistent with the innocence of the accused, which may reasonably be true, even though it is not positively proved to be true, the accused would be entitled for acquittal. The accused can prove the non-existence of the consideration by raising a probable defense. If the accused is proved to have discharged the initial onus of the proof of showing that existence of consideration was improbable or doubtful, or the same was illegal, and the onus will be shifted on the complainant. It is true that in a case where accused failed to discharge the initial onus of the proof by showing the non-existence of consideration, the complainant would invariably to be held entitled for the benefit of presumption arising under section 118A of the in his favor. However, the court cannot insist upon the accused to disperse the existence of consideration by leading a direct evidence, as to prove the existence of negative evidence is highly difficult. Hence, under such circumstances, the standard of proof is preponderance of onus contemplated under section 118 and 139 of the Act upon the accused is not as heavy as normally upon the prosecution to prove beyond all the shadow of doubt. Hence, the testimony of BW1 is that the accused is successful in rebutting the presumption envisaged under section 118 and 139 of Negotiable Instrument Act. Accordingly, I answer the point number 1 in the negative. Now, my lord, your lordship kindly see, I got the record. Now, the evidence, my lord, the evidence which your lordship kindly see, evidence of DW1. Kindly see the evidence of DW1, my lord. May I read, my lord? ನಾನು ಫಿರ್ಯಾದಿದಾರ ಮನೆಯಲ್ಲಿ ಪ್ಲಂಬಿಂಗ್ ಕೆಲಸ ಮಾಡಿರುತ್ತೇನೆ. ಹಾಗಾಗಿ ಫಿರ್ಯಾದಿದಾರರ ಪರಿಚಯ ನನಗಿದೆ. ಫಿರ್ಯಾದಿದಾರ ಹತ್ತಿರ ನಾನು 30,000 ಸಾಲ ಪಡೆದುಕೊಂಡಿದ್ದೆ. ಸದರಿ 30,000 ಹಣದ ಪೈಕಿ ಪ್ರತಿ ತಿಂಗಳು 600 ರೂಪಾಯಿ ಬಡ್ಡಿ ನೀಡುತ್ತಾ ಬಂದಿದ್ದೇನೆ. ಸೆಪ್ಟೆಂಬರ್ 2014ರಲ್ಲಿ ನನಗೆ ಸಮಸ್ಯೆಯಾದ ಕಾರಣ ಫಿರ್ಯಾದಿದಾರಿಗೆ ಬಡ್ಡಿ ಹಣ ಪಾವತಿಸಲು ಆಗಿರುವುದಿಲ್ಲ. ಫಿರ್ಯಾದಿದಾರರು ನನಗೆ ಬಡ್ಡಿ ಹಣವನ್ನು ಕೇಳಿದಾಗ ನಾನು ಫಿರ್ಯಾದಿದಾರ ಮನೆಗೆ ಹೋಗಿ ಸ್ವಲ್ಪ ಕಾಲಾವಕಾಶ ಕೇಳಿಕೊಂಡಿದ್ದೇನೆ, ಕೊಡಿ ಎಂದು ಕೇಳಿಕೊಂಡಿದ್ದೇನೆ. ಆಗ ಫಿರ್ಯಾದಿದಾರರು ನನ್ನ ಗಂಡನಿಗೆ ಹುಷಾರಿಲ್ಲ ಮತ್ತು ಕೆಲವು ತಿಂಗಳಿಂದ ಸರಿಯಾಗಿ ಬಡ್ಡಿ ಹಣ ನೀಡುವುದಿಲ್ಲ. ಆ ಕಾರಣ ಭದ್ರತೆಗಾಗಿ ಏನಾದರೂ ಕೊಡಿ ಎಂದು ಕೇಳಿದಾಗ ನಾನು ಫಿರ್ಯಾದಿದಾರಿಗೆ ಭದ್ರತೆ ಸಹಿ ಮಾಡಿದ ಖಾಲಿ ಚೆಕ್ ಅನ್ನು ನೀಡಿರುತ್ತೇನೆ. ದಿನಾಂಕ 19/2/2015 ನಾನು ಫಿರ್ಯಾದಿದಾರಿಗೆ ಚೆಕ್ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಅದೇ ದಿನ ಫಿರ್ಯಾದಿದಾರರು ನನ್ನಿಂದ ಆನ್ ಡಿಮಾಂಡ್ ಪ್ರಾಮಿಸರಿ ನೋಟಿಗೆ ಸಹಿ ಪಡೆದುಕೊಂಡಿರುತ್ತಾರೆ. ದಿ ಫ್ಯಾಕ್ಟ್ ದಟ್ one of the observation of the trial court or reason of the trial court that I have not examined the witness on the on-demand witness who has signed on-demand note. Now he has admitted that there is a on-demand promissory note. ನಾನು ಚೆಕ್ ಕೊಟ್ಟು 3-4 ತಿಂಗಳ ನಂತರ ನನ್ನ ಮನೆಗೆ ಬಂದು ತಿಳುವಳಿಕೆ ಪತ್ರ ಬಂದಿರುತ್ತದೆ. ಆಗ ನಾನು ಫಿರ್ಯಾದಿದಾರ ಮನೆಗೆ ಹೋಗಿ ಸ್ವಲ್ಪ ದಿನ ಕಾಲಾವಕಾಶ ಕೊಡಿ, ನಾನು ಹಣ ಪಾವತಿಸುತ್ತದೆ ಎಂದು ಕೇಳಿಕೊಂಡಿದ್ದೇನೆ. ಅದಾದ ನಂತರ ಫಿರ್ಯಾದಿದಾರರು ಈ ಪ್ರಕರಣವನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ನಾವು ಇನ್ ದಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮೈ ಲಾರ್ಡ್, he says ಸಾಕ್ಷಿಗೆ ನಿಶಾನೆ P5 ತೋರಿಸಲಾಗಿ ಅದರಲ್ಲಿರುವ ತಮ್ಮ ಸಹಿಯನ್ನು ಸಾಕ್ಷಿಯು ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾರೆ. He has admitted the signature in demand promissory contained in the demand promissory note. ನಾನು ನಿಶಾನೆ P5ಕ್ಕೆ ಸಹಿ ಮಾಡುವ ದಿನಾಂಕದಂದು ಅದರಲ್ಲಿ 5 ಲಕ್ಷಕ್ಕೆ ಬರೆದುಕೊಟ್ಟಿದ್ದೆ ಎಂದರೆ ಸಾಕ್ಷಿಯು ಅದು ನಾನು ಖಾಲಿ ಕಾಗದಕ್ಕೆ ಸಹಿ ಮಾಡಿದ್ದೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನಾನು 5 ಲಕ್ಷ ಎಂದು ಬರೆದಂಥ ಆನ್ ಡಿಮಾಂಡ್ ಪ್ರಾಮಿಸರಿ ನೋಟಿಗೆ ಸಹಿ ಮಾಡಿದ್ದರೂ ಸಹ ನಾನು ಖಾಲಿ ಪೇಪರ್ಗೆ ಸಹಿ ಮಾಡಿರುತ್ತೇನೆ ಎಂದು ಸುಳ್ಳು ಸಾಕ್ಷಿ ನುಡಿಯುತ್ತೇನೆಂದರೆ ಸರಿಯಲ್ಲ. ಫಿರ್ಯಾದಿದಾರರಿಗೆ ಹಣ ಪಾವತಿ ಮಾಡಬೇಕೆಂದು ನಾನು ನಿಶಾನೆ P1 ಚೆಕ್ಕನ್ನು ಕೊಟ್ಟು ಅದು ಬ್ಯಾಂಕಿಗೆ ಹಾಜರುಪಡಿಸಿದರೆ ನಗದೀಕರಣವಾಗುತ್ತದೆ ಎಂದು ತಿಳಿಸಿದ್ದೆ ಎಂದರೆ ಸಾಕ್ಷಿಯು ಭದ್ರತೆಗಾಗಿ ಖಾಲಿ ಚೆಕ್ಕನ್ನು ಕೊಟ್ಟಿದ್ದೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನಿಶಾನೆ Lord, if for his case is my lord, he has executed the promissory note. When I demanded the money, my lord, he has given the check.
Yes.
Now he says adu ಭದ್ರತೆಗಾಗಿ ಕೊಟ್ಟಿದ್ದೇನೆ ಅಂತ ಹೇಳಿ. There is no occasion for him to give 2 documents for one transaction. ನಿಶಾನೆ P3ರಲ್ಲಿರುವ ಅಂಶಗಳು ಸತ್ಯಸಂಗತಿಯಾದ ಕಾರಣ ನಾನು ನಿಶಾನೆ P3ಕ್ಕೆ ಉತ್ತರ ನೀಡಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. Lord, even for the legal notice, my lord, he has not replied. Therefore, under section 118, my lord, I have proved the initial burden. Once I am able to prove the initial burden, my lord, it is for the accused to prove that amount was not lent. Now, insofar as my financial capacity is concerned, my lord, I have deposed that my husband is working as a commission agent in the APMC, and he used to keep the money in the house. Now, no doubt, my lord, I have not produced any document to show that he was working as a commission agent. But before this honorable court, my lord, I have made an application for production of the document, which your lordship will get it, IA number 2, filed under section 378 of the then Criminal Procedure Code. Kindly come to page number 35, my lord. In page number 35 of the paper book. Now, to show my capacity to lend, my lord, this is a sale deed, my lord, executed by me in favor of one Mr. Ayyappa. I have sold 3 acres of land for a sum of rupees 13,91,250 in the year 2006. Now, one of the conclusion arrived by the trial court.
What is the consideration amount?
13 lakhs, 13,91,250. Why I have produced this document before your lordship is to show my capacity that I have the amount to lend. Now, another document, my lord.
But lending was during?
It was in the year 2015.
February 2015.
2015.
But it was during 2006.
2006 is the sale deed. My lord, the observation of the trial court or finding of the trial court, my lord, I have no capacity to lend. I am a housewife. Therefore, to show that I had a capacity to lend the amount, my lord, these documents were produced. Therefore, the finding of the trial court that I have no capacity cannot be believed at all. Under these circumstances, my lord, my respectful submission to your lordship is, for a moment, my lord, I may be permitted to read section 118 of the Negotiable Instrument Act. 118, my lord. Now, presumption as to the Negotiable Instrument Act, until the contrary is proved, the following presumption shall be made of consideration that every negotiable instrument was made or drawn for a consideration, and that every such instrument, when it has been accepted, endorsed, negotiated, or transferred, was accepted, endorsed, negotiated, or transferred for consideration as to the date, that every negotiable instrument bearing a date was made or drawn on such a date as to the time and acceptance, that every accepted bill of exchange was accepted within a reasonable time after its date and before its maturity, as to the time of transfer, that every transfer of negotiable instrument was made before its maturity, as to the order of endorsement, that endorsement appearing upon the negotiable instrument were made in order in which they appear thereon, as to the stamp, that last promissory note, bill of exchange, or check was duly stamped, that holder is a holder in due course, that the holder of the negotiable instrument is a holder in due course, provided that where the instrument has been obtained from its lawful owner or from the person in a lawful custody thereof by means of an offense or fraud, or has been obtained from the maker and accepted thereof by means of offense or fraud or unlawful consideration, the burden of proving that the holder is a holder in due course lies upon him. Therefore, my lord, initial burden I have proved that I have lent the money. Therefore, the finding of the trial court arrived under section 118 is incorrect, my lord.
Yes.
Therefore, my respectful submission to your lordship is, I am entitled for the relief as paid in the appeal. Oh.
Respondent unrepresented. Vachan Gowda.
Now, in fact, my lord, before the trial court, it was also recorded in the order sheet. He came for compromise, saying that he will pay 4 lakhs. But unfortunately, my client has not agreed for that amount, and she demanded entire 5 lakhs.
Where is such
that
offer was given?
Compromise amount has not been mentioned, but it is mentioned in the order sheet, my lord. I will point out.
Let it be.
Yes.
Not necessary.
Yes.
So, order sheet tagoli. Third learned counsel for the appellant. Respondent and his counsel absent, no representation. Appeal is of the year 2019. We do not find any reason to adjourn the matter. However, to afford final opportunity list on first ಮಾಡಿ on the judgment ತಗೊಳ್ಳಿ. Please be seated.
Yes.
The complainant in CC CC number 226 of 2016 on the file of the Leonard JMFC bracket Nally Fourth Court at Mysore. Sorry. Fourth Court at Mysore. Is impugning the judgment dated 10th January 2019, acquitting the respondent accused for the offense punishable under section 138 of an act. Parties are referred to as per their end. Brief facts of the case are that the complainant has filed the private complaint in PCR 592 of 2015 before the trial court against the accused, alleging commission of the offense punishable under section 138 of an act. It is contended by the complainant that he was well acquainted with the accused and his family since several years. The accused approached the complainant during February 2015 and requested for a hand loan to meet the legal necessity. Accordingly, the complainant lent an amount of ₹5 lakh to the accused. The accused has executed an on-demand promissory note with consideration receipt for ₹5 lakh, agreeing to repay the loan amount within 6 months with interest. In spite of that, the accused had not repaid the loan amount nor paid the interest. When the complainant insisted for payment of the loan amount, the accused had issued the check bearing number 160172 drawn on Bank of India for ₹5 lakh towards discharge of the legally enforceable debt. When the check was presented for encashment, the same was dishonored as there was insufficient funds in the account of the accused. A legal notice was issued by the complainant to the accused. In spite of service of notice, the accused has not repaid the loan amount, check amount, nor replied to the legal notice. Thereby, he has committed the offense punishable under section 138 of an act. Accordingly, the complainant requested the trial court to take cognizance of the offense and to initiate legal action. The trial court took cognizance of the offense and registered CC number 7. The accused appeared before the trial court, pleaded not guilty for the accusation made against him. The complainant examined himself as PW1, got marked exhibit P1 to 5, support of his contention. The accused has denied all the incriminating materials in his statement recorded under section 1313 of CRPC. He examined himself as DW1. The trial court, after taking into consideration all these materials on record, came to the conclusion that the complainant has not proved her capacity to lend and also actual lending of the amount. The accused has probabilized his defense, and therefore the legal presumption under section 139 stands reverted. Accordingly, the accused was acquitted for this offense under 138 of an act. Being aggrieved by the same, the complainant is before this court. Third so-and-so. Then counsel for the complainant contended that the complainant has filed the private complaint. He specifically pleading that the complainant was known to him since several years, and he had requested for a hand loan of ₹5 lakh. Accordingly, the loan was given on 20th February 2015. After taking the loan, the accused had executed the on-demand promissory note with the consideration receipt on the same day, which is produced as per Exhibit P5. Towards the repayment of the loan amount, the accused had issued the check as per Exhibit P1 for ₹5 lakh, which is dated 20th September 2015. On presentation of the check, it was dishonored as there was insufficient fund in the account of the accused. The legal notice as per Exhibit P3 was issued. It was served on the accused as per Exhibit P4. In spite of that, there is neither a reply nor repayment of the check amount. Thereby, the accused has committed the offence punishable under Section 138 of an Act. Next part. Then counsel contended that the complainant examined himself as PW1 and got marked the relevant documents. During cross-examination, nothing has been elicited from PW1 to disbelieve his version. The accused has stepped into the witness box and taken the defense that he had obtained the loan of only ₹30,000 and not ₹5 lakh as contended by the complainant. The accused admitted issuance of the check Exhibit P1 with his signature and also admits his signature found on Exhibit P5, the on-demand promissory note and the consideration receipt. Specific defense was taken that by the accused that he had signed the blank check and the blank DP note. The said defense was never verbalized by the accused. Under such circumstances, when the accused admits there is a signature found on the check Exhibit P1 and the DP note Exhibit P5, the legal presumption under Section 118 and 139 of an Act would arise. The accused has never probabilized his defense and therefore failed to rebut the presumption. In spite of that, the trial court committed an error in proceeding to hold that the accused is successful in probabilizing his defense and rebutting the legal presumption. The trial court has placed the burden on the complainant to prove her capacity to lend and actual lending of the amount, even when the accused admits issuance execution of the DP note as per Exhibit P5 and issuance of the check as per Exhibit P1. Next, when counsel submitted that, since the trial court has formed an opinion that the complainant has not proved her capacity to lend, she has filed EA number 2 of 2019 with additional documents. The first document is the copy of the sale deed dated 28th August 2006, executed by the complainant and her children, selling the landed property in favor of a third party for a sum of rupees 13,91,250. Further, a receipt issued by APMC Committee Mysore in favor of the husband of the complainant is also produced, according to which the husband of the complainant is working as a commission agent in APMCI. Hereby, The complainant is successful in proving her capacity to lend and also lending the amount to the accused. Hence, he prays for setting aside the impugned judgment of acquittal passed by the trial court by allowing the appeal. Yes. To hear the counsel for the respondent, final. Date code. Short date. Yes.
Figure number 27, Ganesha with Krishna Swami.
For the appellant in this case.
Yes. It is for the respondent's argument. Date kodtar. Yes.
For the appellant in this case, appellant is the complaint before the trial court, 138 matter.
No, trial court record is not received, not yet received. Awaited. Await trial court records. Let it come afterwards. I'll hear. ಯಾವಾಗ ಕಾಲ್ ಆಗಿದ್ದು PCR ಲಾಂಗ್ ಬೇಕಾದ್ರೆ ರಿಮೈಂಡರ್ ಹೋಗುತ್ತೆ. Issue reminder to the trial court to send the trial court records.
It's for the appellant.
No, they same.
Well, it is dismissed for default. Well, it has to be remanded back.
It is recalled.
Well, there was no proceeding that was held. It was only the sworn statement that was done, and then they have taken the bail, my lords. It was dismissed for default for non-appearance.
Then respondent is served unrepresented. Issue notice to respondent. Survival. Good. Report record ಏನು ಬಂದಿಲ್ಲ. I'll receive the trial court records. Thereafter, I will pass orders.
But there was nothing. There was only sworn statement that was read, my lord. There was no other.
The order sheet you have produced.
Yes, my lord, I produced the entire order.
Entire order sheet.
Yes, my lord.
Sworn statement.
My lord, I have not produced the sworn statement, but I have produced the entire order sheet.
Sworn statement ಬೇಕಲ್ಲ. ಇರಿ order sheet ನೋಡಿ.
Page 23.
Yes, what is your justification for your absence before the trial court?
My lords, the last occasion, my lords, we have been present, my lords, but they have come to a conclusion that we have not been present for 5 years, but been present. But in last occasion, my lords, my counsel met with an accident, so he was not in a position to attend. But the very next day, when he got to know,
No, accused has appeared before the trial court.
my lords,
Accused was accused had appeared before the trial court.
no, my lords, the accused was only present on the day, my lords, on only to obtain the bail. After that,
Thereafter,
he was not been present.
NBW was issued.
Yes, my lord, it's been issued. He was only present once, my lord.
First, when NBW was issued,
My lord, it was first issued
25 to
25/2, my lord.
ಇದು ಮೊದಲಿನ ಕೇಸ್ ತಗೊಳ್ಳಿ. ಮೊದಲಿನ ಡಿಕ್ಟೇಷನ್ ಮಾಡ್ತೀನಿ.
On 8/7, my lord, they advanced the case.
What is the date of taking cognizance?
Well, that was on, well, it's on, it was on 14th. That's 14/6 one.
14/6 is the next date.
Next
here.
date.
There is the previous date. That is on 23/3.
23/3, my lord, 23/3, 2019.
Same day.
Yes, madam. We'll let this one second.
When he appeared,
Madam,
when he appeared before the trial court.
my lord, the accused, madam.
Huh.
My lord, accused appeared on 8/7, my lord. The case was advanced. 8/7/2022. My lord, page number, running page 19. They advanced the case and.
No, in the meantime, even after service of notice, he had not appeared.
Yes, my lord.
NBW was issued.
Yes, my lord. And it was recalled and it was posted for plea on 21/7/22. From then, the accused was not present, my lord.
When it was advanced,
My lord, 8/7/2022, my lord.
thereafter,
My lord, there was no presence of the accused, but we've been taking NBW.
when the NBW was issued.
My lord, we have, my lord, the NBWs was issued on the, my lord, on all
12/9.
the subsequent dates, my lord, because neither the counsel nor the accused was present.
Then,
My lord, we've been, my lord, the counsel was not been present for the last 2 dates. And it was dismissed for default content that we have.
what date?
My lord, it was dismissed on, my lord,
24.
27/4.
20th.
No, 27/4. 24th, it was directed to furnish correct address.
Oh,
27/4 was the, my lord, it was dismissed.
yeah, where is the order sheet?
My lord, it's page number 23, my lord.
20?
Turning page 3.
23 ನೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು.
Yes, my lord. So it's mentioned as 27/4.
Page number 23 is
Yes, my lord.
dismissed for his,
Default.
it shows complainant is not interested to proceed with the case.
Yes.
Hence, case of the complainant is dismissed. What was the court order?
My lord.
There is mention that the complainant has not chosen to comply with the court order. What is that?
My lord, to be present, my lord, but we have been present on 22/8/22, 12/9/22. We've been present, but there was no representation from the accused end. But the counsel for the complaint was been present, my lord, on the several other occasions, and he's been taking NBW.
from 2022 till 2024,
Yes, ma'am. But,
even though the NBW was issued,
yes, ma'am.
his presence could not be secured,
No, my lord.
then
My lords, we tried, my lords, and they've asked us to furnish a correct address.
Hmm.
We tried to contact the client, my lord. They say that he's in the same address.
then why it was not executed?
Well, we have paid the process.
Even if it is, even if this appeal is to be allowed, what purpose it will serve?
Lord, sir, we would like to take a hand from NBW through hand, my lords, and execute it.
How can you take that? You are not authorized to execute the NBW.
Lords, but
Huh? Even if it is allowed, no purpose would be served. Since 2022 till 2024, continuously NBW was issued. Was not never executed. Even before 2019 to 2022, NBW was issued. Even that was not executed.
well, from 19 to 22, my lords, there was this COVID limitation was going on.
Even
So
then.
after that, my lords, it was executed.
COVID ಎಲ್ಲ ಮುಗೀತಲ್ಲ,
Yes,
22
my lord.
to
He was present and then he was taken.
ಏನಿಲ್ಲ, ಸುಮ್ನೆ no purpose would be served. Why it is well or ಹೇಳಿ ನಾನು? What is the justification?
Lords, we'll try to procure the correct address once again, my lord. We'll try to get the.
ಅಷ್ಟೇ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್ ಅಂತ ಹೇಳ್ಬಿಡೋದು, ಸುಮ್ಮನೆ ಇರು. Issue NBW, reissue NBW.
No, we'll try to.
No purpose would be served.
We'll try to get the correct address. We'll procure.
It is served. Lady, husband has received, that was very sufficient. Sufficient ಅಂತ hold ಆಗಿದೆ. Immediately after service of notice ಅಂತ ಬರ್ತಿದ್ವಿ. Respondent remained absent in spite of service of notice. Third learned counsel for the appellant, who is the complainant before the trial court in CC number 7. The certificate copy of the order sheet discloses that the complaint was presented on 23/3/2019. On the same day, the cognizance was taken. In spite of service of notice, the accused remained absent before the trial court. The NBW was issued on 12/11/2019. However, his presence could not be secured in spite of issuance of NBW. Case was advanced on 8/7/2022 through represented by her advocate. The NBW got recalled. He was ordered to be released on bail. It is pertinent to note that thereafter, the accused never appeared before the court. In spite of issuance of NBWs repeatedly. On 24/2024, complainant was absent and the complaint was came to be dismissed for default, that is for non-prosecution. Next. On going through the order sheet, it is clear that The trial court has not directed the police to execute the NBW. It is only stated that the accused is not found in the address. To accept such endorsement, the accused, the trial court had not issued the notice or summons, but the police was expected to execute the NBW against the accused wherever he is throughout the country. No such effort appears to have been done. The contention of the learned counsel for the appellant that on the date when the complaint came to be dismissed, his advocate was not in a position to attend the court, and she was also not attended the court under the bona fide impression that her advocate will take care of the case. The reasons assigned are reasonable. The grounds urged are very reasonable. And hence I accept the same. Accordingly, the order dated so and so dismissing the complaint for default is set aside. CC so and so is restored on file and remanded back to the trial court for fresh consideration in accordance with law. The complainant is directed to make efforts to find out the correct address and to furnish the same to the trial court. And the trial court shall secure the presence of the accused and to deal with the matter in accordance with law. Yes, appeal is allowed.
Grateful.
No doubt. Yes, other matters to that.
ಇಬ್ಬರು ಬಂದ್ರೆ ಅಂಡಂತಾನೆ ಬಂದು ಅಂಡಂತ
ಚೂರು ನೋಡ್ಬೇಡಿ ಮಾತ್ರ ಇರ್ಬೇಕಾ ಸುಮ್ಮನೆ ಈ ಸಳೆ ಕಾದು ಹೋಗಿದೆ.
ಇನ್ನ ಕಳಿಸ್ಬಿಡ್ತೀವಿ.
ಎಲ್ಲೂ ಇನ್ನೇ ಇರ್ಲಿಲ್ಲ ಎಕ್ಸ್ಪೆಕ್ಟ್ ಇನ್ನೇ ಇರ್ಲಿಲ್ವಾ
ನಿನ್ನೆ ರಜಾ ಒಂದ್ ದಿವಸ ರಜಾ.
ಎಲ್ಲದಕ್ಕೂ ಒಳ್ಳೆ ರಿಲೀಫ್
ಹಿಂದೆ ಇರುವಾಗಲೇ ಚೆನ್ನಾಗಿರುತ್ತೆ
ಇಲ್ಲದಕ್ಕೂ ಒಳ್ಳೆ ರಿಲೀಫ್
ಅಂತ ಹಿಂದೆ ಇರುವಾಗ
ರಿಲೀಫ್ ಸಿಕ್ತು ಅಂದ್ರೆ
ಅಂತಾನೆ ಕೊಟ್ಟಿರೋದು. ಇದ್ದೇ ಕೂಡ ಆಯ್ತು. ಅದನ್ನ ನಾವೇ ತಗೋಬೋದಾ ಕಾಫಿ?
ಫೈನಲ್ ಆರ್ಡರ್ ಯಾರು ತಗೊಳ್ಳ ಫೈನಲ್ ಆರ್ಡರ್ ತಗೊಳ್ಳ
All minor injuries. ನೀವು ಬಂದಿಲ್ಲ 5 minutes late. ಎಷ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್ ಕರಿತೀವಿ? ಕರಿತೀವಿ, ಪಾಸ್ವರ್ಡ್ ಎಲ್ಲ ಕರಿತೀವಿ. Three matters. Orders first time, serial number 1 and 2.
HCP to take notice for responding. Private break, issue notice. Issue notice.
Serial number 3 for orders, Ramchandra Alinath.
Counsel for the petitioner is absent, no representation, please stand.
Serial number 4, Sunil S. Narayan, Virupakshaya.
Medical records.
My lord, I am filing the medical report of the petitioner. my lord. Lord, in the medical report, my lord, he was diagnosed with grade A reflux esophagus with hiatus hernia, my lord. He was advised to take medicines, my lord, and he has sent back to his parent jail at Davangere, my lord. Now it's fine, my lord.
He was treated where?
He was treated in Bangalore, my lord.
Which hospital?
Institute of Gastroenterology, Science and Organ Transplant Hospital, the Victoria Hospital. He was sent to Bangalore, my lord, on 8/10/2024. He was sent back to Davangere on 31/10/2024. He was treated here. He was advised to take some medicines.
Now he is in
He is
Davangere.
in Davangere jail.
He has also taken treatment in Chitgiri Hospital.
Initially he was taken.
Initially, my lord.
ಆಯ್ತು, now he is fine.
Merit ಮೇಲೆ ಮಾಡ್ತೇನೆ. Kindly have 2 days, but I will merit ಮೇಲೆ ಮಾಡ್ತೇನೆ. ಆಗ when I withdraw, it was not on merit, ಸ್ವಾಮಿ. ಹಾಗಾಗಿ I will argue on merits.
ಮೊದಲಿನ petition. Earlier petition you have withdrawn, not on merits.
Not on merits.
Then the HCGP submitted and filed a memo with the report of the Chief Superintendent of Central Prison Bengaluru and also the Chief Medical Officer, Central Prison Hospital, along with the medical records. Then counsel for the petitioner days for time to address his arguments on merits.
8th.
This term. This term, yeah, could
Serial number 5, B Latif.
ಕೊಡ್ತಾರೆ ಒಂದೇ ನಿಮಿಷ. Yes,
Lord, the petitioner is accused number 4, my lord.
accused number 4.
Please,
In all, how many?
in all 10 accused in the charge sheet. Lord,
What are the offense?
the offense, major offense is 302, 323, 324, 149, 143, 146, 137, 120B.
Arrested on?
Arrested on 14/4/2021. 14/4/2021.
2021. What about other accused?
Lord, accused number 3, 5 to 10 are enlarged on bail. And lordship has granted bail to accused number 2 also, except 1 and 4 others are all bail.
What about 2?
2 was enlarged on bail by this honorable court. Lordship has granted bail on in criminal petition 9609/2020.
We produced it.
Produced at page number 105.
This petition. Yes.
ಆಮೇಲೆ ಇದು ಕೊಟ್ಟಿಲ್ಲ. ಇದು ಕೊಟ್ಟಿಲ್ಲ. Here is the circular. The allegation of assault by accused number 1 and the allegation against this petitioner is he has pushed the deceased by hand. Allegation against 2 also the similar allegation, and he was also assaulted by hand. The entire charge sheet allegations and eyewitness statements indicates not A1 has assaulted to the deceased. Charge sheet column number 17, Lord. Page number 59. Now, Lord, still the evidence is not yet commenced. Is more than 3.5 years in custody. As many as 47 witnesses have been cited.
How many CWs 1 to?
47. Order sheet I have produced at page number 116. Still it is posting for fixing of date of trial. Charge sheet allegation, Lord. That's page number 59.
1 minute.
Please.
Yes, what do you say? Parity.
My lord, on merit, my lord, with respect of this petitioner, my lord, page number 100 and 100, my lord, it was dismissed, my lord, accused number 1 and 4, my lord. On merit of the matter, my lord, after filing the charge sheet. The observation is page number 103, my lord.
When it was dismissed?
The
Dismissed on 19th
January 2022. Subsequently, other accused are enlarged on bail. A2 is enlarged in December 2021. ಇದನ್ನು ಅವಾಗ
ಅಲ್ಲ, that was considered in that petition itself, my lord. Enlargement of accused number 2. The parity, ground of parity was considered and it was dismissed, my lord. In para number 6, my lord, page number 103.
103.
The reasoning given by this court while exercising discretion in favor of accused number 2 will not come to the aid of these petitioners when specific overt act allegations are made against them. And this court observed that accused number 2 only assaulted with hands. And such being the case, it is not a fit case to exercise the discretion.
What is the overt act by this petitioner?
Only allegation of.
He came with accused number 1 on bike, my lord, and he pushed the deceased, my lord. It was the allegation.
Page number 100, the petitioners are accused number 1 and 4.
Yes, my lord. This petitioner is accused number 4, my lord.
ಅದೇ ಮಿಸ್ಟೇಕ್ 1 ಜೊತೆ ಹಾಕಿದ್ರೆ ಅದಕ್ಕೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
The only accused number 1 and 4, my lord, they went behind the deceased. Accused number 4 pushed him to the gutter, my lord, and after that he assaulted.
Fatal injuries caused by the
Accused number 1.
And injuries caused to CWs 12, 16 to 20. Also by accused number 1. Accused number 1 and
This is
4.
the only allegation against accused number 4, my lord. As once it's already dismissed on
the
merit.
deceased. He pushed the deceased.
Yes, ma'am.
He has not assaulted the
No, ma'am.
injured.
That allegation is not.
ಅದೇ ಆ ಮಿಸ್ಟೇಕ್ ಹಾಗೆ ಮಾಡಿ ಮೇನ್ ಅಕ್ಯೂಸ್ ದೋರ್ಸ್ ಹಾಕಿರಿ. Petitioner being accused number 4. In crime number 58 of 2021, also in Chikmagaluru Town Police Station. He is seeking grant of ಬೇಡ ಅದೆಲ್ಲ ಮರಿ ಹಾಕ್ಕೊಳ್ಳಿ. ಇಲ್ಲಿ reasons ಅಲ್ಲಿ petitioner being accused number 4 is seeking grant of bail. He was apprehended on 14/4/2021. Since then he is in judicial custody. Initially, the FIR was came to be registered against accused numbers 1 to 4. After investigation, charge sheet came to be filed against accused number 1 to 10. It is the contention of the prosecution that accused number 1 assaulted the deceased with an iron rod, caused a fatal injury, which resulted in his death. It is also the contention of the prosecution that it was accused number 1 who assaulted the injured CW 16 to 18. As per column number 17 of the charge sheet, the only allegation made against the present petitioner is that he came on a motorcycle, pushed the deceased with hands. It is not the contention of the prosecution that the petitioner was armed with any weapon or assaulted either the deceased or the injured with the same. Next para, it is brought to the notice of the court that accused number 2, 3, 5 to 10 are already enlarged on bail. It is stated that it is only accused number 1 and 4 who are in judicial custody. The allegations against accused number 1 is very serious in nature. But no such allegations have been made against the present petitioner. Under such circumstances, I am of opinion that the petitioner is entitled for grant of bail by applying the principle of parity. Moreover, it is stated that 47 witnesses are cited by the court, and none of them are examined till date. Considering all these facts and circumstances, I am of opinion. Yes, allowed. Antecedents in illa.
Illa.
Yes. Like this
Serial
contention.
Bill number 6, Chandrasekhar.
the last occasion, my lord, your lordship has heard this matter
Yes.
and posed a question to the SAP. Lord, is there any antecedent?
No, according to her, he is a rowdy shooter.
Rowdy sheeter,
My lord,
not
I'm
rowdy
furnishing the
sheeter.
documents to.
Similar type of my lord crimes, my lord, 2016 and 2019. Thereafter, my lord, he did not.
A rowdy sheet open agida.
Illa illa.
Rowdy sheeter, he was a rowdy sheeter, my lord, and there are 4 cases against him. my lord.
ಅದ್ರಲ್ಲಿ ಒಂದರಲ್ಲಿ
Yeah,
ಅಕ್ವಿಟಲ್
share
ಆಗಿದೆಯಂತೆ.
Crime numbers.
ಕ್ರೈಮ್ ನಂಬರ್ 60 of 2016 ಅಲ್ಲಿ ಅಕ್ವಿಟ್ ಆಗಿದೆಯಂತೆ.
ಎಲ್ಲಿದೆ?
60 of 2016.
50 of 2006. ತಪ್ಪಾಗಿ ಬರ್ಕೊಂಡಿದ್ದೀನಿ.
ಹೌದಾ? 15.
I'm-
ಅದು ಒಂದರಲ್ಲಿ ಅಕ್ವಿಟಲ್ ಆಗಿದೆ. ಇನ್ನೆಲ್ಲ 2016 ಅಲ್ಲಿ
Very
ಆಗಿರುವಂತ.
serious allegation, sir.
There is no.
ರೌಡಿ ಶೀಟರ್ ಇವರು. ರಿಯಲ್ ಎಸ್ಟೇಟ್ ದಂಧೆ ಮಾಡಿಕೊಂಡು ಗುಂಪು ಕಟ್ಟಿಕೊಂಡು ಅಮಾಯಕ ಜನರಿಂದ ಭೂ ಕಬಳಿಕೆ ಮಾಡುವುದು, ಅಮಾಯಕ ಜನರಿಗೆ ಬೆದರಿಕೆ ಹಾಕಿ ಕಡಿಮೆ ಬೆಲೆಗೆ ಭೂ ವ್ಯವಹಾರಗಳನ್ನು ಮಾಡುತ್ತಿದ್ದು, ಜಮೀನು ಕೊಡದಿದ್ದರೆ ಅವರ ಸಹಪಾಠಿಗಳನ್ನು ಬಿಟ್ಟು ಅವರ ಮನೆಯ ಹತ್ತಿರ ಕಳಿಸಿ ಗಲಾಟೆ ಮಾಡಿ ನಿಮ್ಮನ್ನು ಮುಗಿಸುತ್ತೇನೆ ಎಂದು ಬೆದರಿಕೆ ಹಾಕಿದ ಪ್ರವೃತ್ತಿ ಉಳ್ಳವನಾಗಿರುತ್ತಾನೆ. ಗ್ರಾಮದಲ್ಲಿ ಶಾಂತಿ ಭಂಗವನ್ನು ಉಂಟು ಮಾಡುವ ಸಾಧ್ಯತೆ ಇದೆ.
ಇದೆಲ್ಲ 2016 ಅಲ್ಲಿ ಆಗಿರುತ್ತೆ.
16 ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ರಿಪೋರ್ಟ್ ಇದರಲ್ಲಿ ಕ್ರೈಮ್ ನಂಬರ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ? 50
FIRs have produced, my lord.
50 and 102 of 2016.
Crime number 12 of 16, crime number 50 of 16.
12 ಎಲ್ಲಿದೆ?
102 of 16, my lord. The offenses are 324, 320, 354, 323. Those are the offenses, my lord. Those involved.
ರೌಡಿ ಶೀಟ್ ಓಪನ್ ಆಗಿದೆ ಮೇಲೆ ಆರ್ಡರ್ ಆಗಿದೆ. ರೌಡಿ ಶೀಟರ್.
After 2016, my lord, there is no antecedent.
What happened to the rowdy sheet?
Lord, rowdy sheeter open ಆಗಿರೋದ್ರ ಬಗ್ಗೆ
ಇದೆಯಲ್ಲ ಆರ್ಡರ್ ಇದೆ. ಪ್ರೊಡ್ಯೂಸ್
ನನಗೆ ಮಾಹಿತಿ ಇಲ್ಲ ಮೇಡಮ್, ಕೊಡಿ. ಅಲ್ಲ, even assuming for a moment thereafter not he did not involve. Not our.
She has produced certain documents where there are serious allegations made against him. You verified on the last hearing, you disputed the fact.
ಹೌದೌದು, ನನಗೂ ಕೂಡ ಗೊತ್ತಿರಲಿಲ್ಲ, ಪಾಪ ರೆಫರ್ ಮಾಡಿದ ಅಡ್ವೊಕೇಟಿಗೂ ಗೊತ್ತಿರಲಿಲ್ಲ.
ಸರಿ,
ಅವ್ರಿಗೆ ಕೇಳಿದ್ಮೇಲೆ ಹೌದು
I had shown it to the instructing counsel.
ನೋಡಿ, ಅವ್ರಿಗೆ ನಾನು ಕೇಳ್ತೀನಿ, ಏನಪ್ಪ ಈ ತರ ಎಲ್ಲ ಮಾಡಿದ್ಯಾ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
ಅವನೇನು ಇಲ್ಲ, ನಾನು ಅಮಾಯಕ.
ನಾನು ಹೇಳ್ತಾ ಇರೋದು 2016.
ನೀವು ಅದು ಬಂದು ಇಲ್ಲಿ ಅದನ್ನೇ ಹೇಳ್ತೀರಿ,
ಅಲ್ಲ
ನಾವು ಅದನ್ನು ರಿಜೆಕ್ಟ್ ಮಾಡ್ತೀವಿ ಅಷ್ಟೇ. ಆಗೋದಿಷ್ಟೇ.
ಅಲ್ಲ, ಬಟ್ I can
ಎಲ್ಲ
understand
ಅಮಾಯಕರು ಏನ್ ಮಾಡೋದು?
my lord, it is a very heinous offense. Lord, in this case, my lord, ಇವನು ಚಾಕು ಕೊಟ್ಟ ಅಂತ ಹೇಳ್ತಾನೆ. ಚಾಕು ಹಾಕಿದ್ದು ಇಲ್ಲ, ಏನು ಇಲ್ಲ. ಇಂಜುರೀಸ್ ನೋಡಿದ್ರೆ ಸಿಂಪಲ್ ಇನ್ ನೇಚರ್ ಅಂತ ಇದೆ. Considering that aspect, my lord, your lordship has granted the bail to the A1. By imposing any stringent condition, in further, my lord, suppose if he repeats the same thing.
ಇದು ಈಗ ಬಹಳಷ್ಟು ಸಲ ಆಗೋಗಿದೆ.
ಅಲ್ಲ, ಹಿಂದೆ ಯಾವ್ದು ಆ ತರ ನೀವೀಗ ಆರ್ಡರ್ ಮಾಡ್ಬೋದು ಅದೇ ತರ. A1ಗೂ ತಾವು ಹಾಗೇನೆ ಮಾಡಿದ್ದೀರ. Suppose if he repeats the same thing, on page 84.
ಇದೇನಾಗಿದೆ ರೌಡಿ ಶೀಟ್? ಇಟ್ ವಾಸ್ ಆರ್ಡರ್ ಟು ಬಿ ಓಪನ್ಡ್ ಇನ್ ದ month of November 2016.
They have opened it, my lord. They say that he is a rowdy sheeter in that
ಆಮೇಲೆ ಇವಾಗ
area.
after 8 years
I'll produce the recent.
ಯಾಕಂದ್ರೆ ಎಲ್ಲ 2016 ಇದೆ. Subsequently, what is his conduct? ಅವರು ಏನು ಗೊತ್ತಿಲ್ಲ, ಅವ್ರಿಗೆ ಅವ್ರ ಪ್ರಕಾರ ಏನೂ ಇಲ್ಲ, ನೀವೇನೋ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
I can understand, my lord, after 2016, even after the opening of the, assuming for a moment, after the rowdy sheeter is opened, suppose he repeats and he continues the same thing, my lord, definitely, my lord, he do not deserve for the bail.
One is crime number 50 of 16. It's not 2 of 16. Which is the other one?
12 of 16, my lord.
Of which police station?
Same police station, my lord.
Rajanakunte.
Yeah, Rajanakunte police.
3 matters are there.
4, my lord.
Which is the other one?
Another 55 of 19, my lord.
19.
19.
Same Rajanakunte.
ಅದರಲ್ಲಿ
Same police station.
ಒಂದರಲ್ಲಿ ಅಕ್ವಿಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ಹೇಳ್ತಾರೆ.
ಅದು ಯಾವ್ದು ಅಂತ ನೀವು ಕೇಳ್ಬೇಕಲ್ವಾ?
50 last. 50 of 2016.
ಏನಿದೆ, ಏನು ಮೆಟೀರಿಯಲ್ಸ್ ಇಲ್ಲ.
ಅಲ್ಲ, ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ, ನಾವು ಮಾಡ್ಬೇಕಷ್ಟೇನೆ.
ನೀವೇ ಮಾಡ್ಬೇಕು.
ಹೌದೌದು.
He has produced that he is a rowdy sheeter ಅಂತ.
ಅದೆಲ್ಲ ಕಾಪಿ ಕೊಡ್ಲಿ, ನಾನು ಕೇಳಿ. Anyway, he is in custody by another one, make nothing. If my lords, my lord, you will also may kindly, by imposing any, I can understand, my lord, if he continues the same
ಕಾಪಿ
offense.
ತಗೊಳ್ಳಿ, ಏನಾಗಿದೆ? HCP ಫೈಲ್ ಇದು ಕೊಡ್ತಾ ಇದ್ದೀರಿ, ಕೋರ್ಟಿಗೆ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
Yes, my lord.
Along with the memo ಕೊಡಿ.
Yes, my lord.
File a memo along with the documents to contend that crime number 50 of 2016, crime number 12 of 16, 50 of 16, 102 of 16,
ಅಲ್ಲ, ತೋರಿಸಿ ಬರ್ಕೊಂಡಿದ್ದಕ್ಕೆ
and 55 of 2019 of Rajanakunte police station were registered against the petitioner. The rowdy sheet is ordered to be opened against him as per order dated 3/11/2016. 24/11/2016. When counsel for the petitioner pays for time to verify those records and to make his submissions. Copy ಕೊಡಿ.
Yes, my lord.
Yes, ಯಾವಾಗ? When?
ಮುಂದಿನ ವಾರ ಯಾವ?
Yes, ಕೊಡಿ. It's for a week's time.
12, 13. That is 13.
Yes.
Serial number 7, Raju CL.
Not for B of IPC.
304.
B.
Sir, ಅದನ್ನ ಮಾಡಿ ಕೊಟ್ಟು.
His petitioner is accused number 1, my lord. In all, there are 3 accused persons, my lord. In all, total 3 accused persons. He is accused number 1, my lord.
Only 4 ಇದಾರಲ್ಲ.
Left out in the charge sheet. 2 persons have left out in the charge.
FIR is against
5 persons.
1 to 5.
Please, ma'am.
Charge sheet.
Only 3, 5 has been left out, my lord. 1, 2, 4 against 1, 2, 4 file charge.
3 and 5.
Left out in the charge. Marriage, my lord, June 22, my lord. Date is not mentioned. Marriage is June 22. Love marriage, my lord, between the deceased and the accused. Date of the incident is, my lord, 11.
Where is the husband?
Husband.
Who are the other accused?
Other accused are mother and brother, my lord. Others have granted bail by this honorable.
Hmm.
18/5/24, my lord, petitioner arrested. She was, my lord, drowning.
When arrested?
18/5/24, my lord. Incident is 11/5/24. She went to her mother's house, my lord. She fell into the pond and committed suicide, my lord, by drowning in the house of her mother.
Yes, what do you say?
My lord, on 11/5/2024, my lord, is the accused number one, my lord, who had called the deceased, my lord.
And abated.
And yes, my lord. The proximity is there, my lord.
But he was not there. Phone ಹೇಳಿದ್ದಷ್ಟೇ. ಆಯ್ತು, charge sheet is already filed. But petitioner, accused number, being accused number 1 is seeking grant of bail. He was apprehended on 18/5/2024. Since then, he is in judicial custody. The mother of the deceased lodged the first information making specific allegations. It is the contention of the prosecution that the petitioner had married the deceased during June 2022 and thereafter he, along with his family members, started demanding dowry and ill-treating her. It is stated that this petitioner, being the husband, assaulted the brother of the deceased and was not providing food to the deceased and her newborn baby. As a result of which, the deceased, along with her baby, came to her parental house on 11/5/2024. The petitioner had called her over phone and abated to commit suicide, as a result of which she committed suicide by jumping into the river or lake.
Pond, my lord, correct.
Into the pond. Initially, the FIR was next paragraph. Initially, FIR came to be registered against accused numbers 1 to 5. Charge sheet came to be filed against accused number 1 to 3, dropping the original accused number 3 and 5. Even though serious allegations are made against the petitioner, admittedly, accused number 2 and 3 are already enlarged on bail. Since investigation is completed, it is not the contention of the prosecution that the petitioner is required for further investigation, allowed subject to conditions.
Serial number 8, Shivamma D.
For petition, madam. Not 302 offense.
Lord, I pray for some time in this matter. Records ಬಂದಿದೆ.
ಏನಾಯ್ತು?
ಅವ್ರಿಗೆ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲಂತೆ. ಅದಕ್ಕೆ ನಾನು ಸಬ್ಮಿಷನ್ ಮಾಡಿ ವಿಡ್ರಾ ಮಾಡ್ಕೋತೀನಿ ಅದಕ್ಕೆ ಸ್ವಾಮಿ. ಅಂದ್ರೆ ಈ 3 ಅಕ್ಯೂಸ್ ಪರ್ಸನ್ಸ್.
ಸಬ್ಮಿಷನ್ ಯಾಕೆ ಮಾಡ್ತೀರಿ? ಸಿಂಪಲ್ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ರೆ ನಿಮ್ಗೂ
ಡೈರೆಕ್ಷನ್ ಕೇಳ್ತೀನಿ ಅಷ್ಟೇ ಸ್ವಾಮಿ. ಇನ್ನು 3 ಅಕ್ಯೂಸ್ ಇದ್ದಾರೆ. A3 is granted bail. Present petition accused number 1. Entire cases are circumstantial evidence.
ಸರಿ.
ಚಾರ್ಜ್ ಆಗಿದೆ, ಸೆಷನ್ ಕೇಸ್ ನಂಬರ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಪೆಟಿಷನ್ 2023 ಇಂದ ಜೆಸಿನಲ್ಲಿ ಇದ್ದಾರೆ.
ಏನು ಡೈರೆಕ್ಷನ್?
ಶಿ ಇಸ್ ಲೇಡಿ. ಅದಕ್ಕೆ ವಿತಿನ್ 4 months ಅಲ್ಲಿ 1 to 15 are the independent witnesses. ಅದಕ್ಕೆ ವಿತಿನ್ 4 months ಅಲ್ಲಿ ಕೇಸ್ ಮುಗಿಸಿ ಡೈರೆಕ್ಷನ್.
ಅಲ್ಲಿ ಪೆಂಡೆನ್ಸಿ ಎಷ್ಟಿದೆ? ಹೂ ನೋಸ್ ಇಟ್.
ಅಲ್ಲ, ಇದು ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಅಲ್ಲ. ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ತುಂಬಾ ಜಾಸ್ತಿ ಇರುತ್ತೆ ಸ್ವಾಮಿ. ಇದು ಬರೀ 3 ಅಂತ ರೆಗ್ಯುಲರ್ ಕೋರ್ಟ್.
ಇರ್ಲಿ, ಎಷ್ಟಿದೆ ಪೆಂಡೆನ್ಸಿ?
ಅಟ್ಲಿ ವಿತಿನ್ 4 months ಅಲ್ಲಿ ಚಾರ್ಜ್ ಆಗಿದೆ ಸ್ವಾಮಿ. 15 ಇಂಡಿಪೆಂಡೆಂಟ್ ವಿಟ್ನೆಸ್ ಇದ್ದಾರೆ ಅಷ್ಟೇ.
15
1 to 15 are independent witness.
ಸಿಸಿ ನಂಬರ್?
ಎಸ್ಸಿ ನಂಬರ್ 219 of 14. 24 219 of 24.
14 ಅಂತೀರಿ.
ಸರಿ 24. 6th ADS ಮುಂದೆ ಚಾರ್ಜ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಅದಕ್ಕೆ ದಿಸ್ ಇಸ್ ಲೇಡಿ. ಎಂಟೈರ್ ಕೇಸ್ ಆನ್ ಸರ್ಕಮ್ಸ್ಟಾನ್ಷಿಯಲ್ ಎವಿಡೆನ್ಸ್ ಸ್ವಾಮಿ.
ಒನ್ಲಿ ಎಕ್ಸ್ಪಿಡಿಯೇಟ್ ಅಂತೀನಿ ನಾನು. 4 months
ಎಕ್ಸ್ಪಿಡಿಯೇಟ್ ಇದ್ರೆ ಮಾಡಲ್ಲ ಸ್ವಾಮಿ. ಒಂದು ಸ್ಪೆಸಿಫಿಕ್ ಡೈರೆಕ್ಟ್ ಅಟ್ಲೀಸ್ಟ್ 4 months, ವಿತಿನ್ 4 months ಅಲ್ಲಿ.
ಏನು?
ನಾನು ರೆಸ್ಪೆಕ್ಟ್
ನೋ ಐಡಿಯಾ. ನನಗೂ ಗೊತ್ತಿಲ್ಲ ಅಲ್ಲಿ ಪೆಂಡೆನ್ಸಿ ಎಷ್ಟಿದೆ ಅಂತ.
ಅಲ್ಲ, ಇಟ್ಸ್ ನಾಟ್ ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್. NDPS ಆಗಲಿ, ಪೋಕ್ಸೋ ಆಗಲಿ, ಆತರ SC/ST ಕೋರ್ಟ್.
ಬೆಂಗಳೂರು ತಾನೆ? ಬೆಂಗಳೂರು
ರೂರಲ್ ಸ್ವಾಮಿ.
ರೂರಲ್ ಹೆವಿ ಕೋರ್ಟ್.
ಆ ರೂರಲ್ ಹೆವಿ ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ಗಳಿಗೆ. ಈ ಕೋರ್ಟ್ಗೆ ಸ್ವಲ್ಪ ಅಷ್ಟಿಲ್ಲ ಸರ್. ವಿತಿನ್ 4 months ಅಲ್ಲಿ.
ಆಯ್ತು, ನಾಳೆ ಕೇಳ್ಕೊಂಬನ್ನಿ ನೋಡಿ.
ಅಟ್ಲೀಸ್ಟ್ 5 months ಅಲ್ಲಿ ಮುಟ್ಬಿಡಿ ಸರ್. ಮತ್ತೆ ಅದು
ನೋಡೋಣ ಪೆಂಡೆನ್ಸಿ ಎಷ್ಟಿದೆ ಅಂತ ನೋಡಿ. ನೀವಾದ್ರೂ
Pendency, I will ask the prosecutor there, madam.
ಎಲ್ಲಿರಿ? NJDG ಓಪನ್ ಮಾಡಿದ್ರಿ, ಈಗಲೇ ಗೊತ್ತಾಗುತ್ತೆ ನಿಮ್ಗೆ ಯಾವ ಕೋರ್ಟ್ನಲ್ಲಿ ಎಷ್ಟಿದೆ ಅಂತ. ಅದು ಮಾಡಲ್ಲ.
ನಮ್ಗೆ ಮಾಡಕ್ ಗೊತ್ತಿಲ್ಲ ಸುಮ್ಮನೆ.
ಏನ್ರಿ ಅದನ್ನೆಲ್ಲ ಕಲ್ತ್ಕೋಬೇಕು ನೀವು. ವಕೀಲರಾಗಿದ್ಮೇಲೆ ಅದೆಲ್ಲ ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಎಷ್ಟು ಟ್ರೈನಿಂಗ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಹೈಕೋರ್ಟ್ ಇಂದ, ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಇಂದ.
ಹೌದು.
ನೀವು ಅದು ಏನು ಗೊತ್ತ ಮಾಡಲ್ಲ.
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್
You can get every information. ನಿಮ್ಮ mobile ನಲ್ಲಿ immediately at your fingertips it will be available.
ಕಲ್ತ್ಕೊಂತೀನಿ ಸರ್. ಈಗ
ನೀವು
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್
ಬರೀ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋದು ದುಡ್ಡು ತಗೊಳ್ಳೋದು ಆದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು? You have to update yourself. ಇಲ್ಲಾಂದ್ರೆ illiterate ಆಗ್ಬಿಡ್ತೀರಿ.
ಕಲ್ತ್ಕೊಂತೀವಿ ಸರ್.
ಡಿಜಿಟಲ್ illiteracy. ಫೋನ್ ಇದೆ ತಾನೆ?
ಇದೆ ಸರ್.
ಹಾ, ಬರೀ ವಾಟ್ಸಪ್ಪಿಗೆ ಯಾವ್ದಕ್ಕಾದ್ರೂ ಬೇಕಾಗಿದ್ದಕ್ಕೆ ಉಪಯೋಗಿಸಿ.
ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ತಿಳ್ಕೊಂಬಂದು ಹೇಳ್ತೀನಿ.
ನೋಡಿ ಅದರಲ್ಲಿ NJDJ ನೋಡ್ಕೊಂಬಂದು ಇಲ್ಲಿ ಹೇಳಿ ನಾನು.
ಸರಿ.
ಯು ಶುಡ್ ಶೋ ಮೀ
ಪ್ಲೀಸ್.
ಹಾ, ಯಾವಾಗ? ನಾಳೆ?
ನಾಳೆಗೆ ಸರ್.
ನಾಳೆ.
ನಾಳೆಗೆ.
ಎಸ್. ವೇಸ್ಟ್ ಫಾರ್ ಟೈಮ್ tomorrow.
After our matters, list one, serial number 17, Rupesh Abhi.
Then counsel for the appellant submits that needful is done. Office to verify. If needful is done, list for orders. Next.
Serial number 27, Ramchandrappa DN.
ಯಾವ್ದು ಮೊದಲು ಕರೆದಿದ್ದೆ ಅವ್ರು? ಮೊದಲು ಕರೆದಿದ್ದೆ 17 ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತಾ? ಆಯ್ತು. 27.
27, Ramchandrappa DN.
Absent, no representation. Appeal is of the year 2008. Only absent, no representation, even when the matter is passed over twice and again and called again at 3:05 PM. Appeal is of the year 2018. Is listed for the fourth time for compliance of office objections. Order sheet dated so and so reached as sender. In spite of that, there is no progress in the matter. It appears the appellant is not interested in prosecuting. Appeal is dismissed.
Serial number 28, V Anand.
Done. Needful is done. Office to verify. If office objections are complied with, list for orders. Yes.
Serial number 29, Manmohan PM.
With appellate in this case, my lords.
Okay. Magistrate order.
As I may be permitted to withdraw and file it before the sessions court, my lords.
Counsel for the appellant seeks permission to withdraw the appeal and to
With the liberty to file it before.
with liberty to prefer an appeal before the appropriate court.
Within
Conditions
4 weeks.
Placed on memo ಹಾಕಿದ್ರೆ memo
My lords,
appeal is dismissed.
delay
with
may be-
liberty to so and so.
my lords, my delay may be condoned, my lords, because.
ಅಲ್ಲಿ ಮಾಡ್ಬೇಕು, ಇಲ್ಲಿ ಮಾಡೋದಿಲ್ಲ. Delay
2022 ಅಲ್ಲಿ ನಾವು ಫೈಲ್ ಮಾಡಿದ್ದೀವಿ.
immediately you file it there. With liberty to prefer an appeal before the appropriate court.
We have filed it in the year
If the
2022, my
appeal is
lords.
preferred immediately and without loss of further time, the appellate court may consider violation of delay caused while prosecuting this appeal before this court. Yes.
Serial number 30, Sanjaya B.
Counsel same dismissed. Next.
Serial number 31, Gopal Goda HK.
Needful done. Just for orders.
Serial number 36, Ashwin S. Aladi.
Needful done. Orders.
Serial number 37, Rudrappa P. It's not coming.
Counsel for the appellant is
Appellant, madam.
you have not complied with.
Complaint, madam.
ಇನ್ನೂ ಇದೆ.
Age difference.
ಏಜ್ ಪ್ರೂಫ್ ಇಲ್ಲ ಅಂತ ಆಧಾರ್ ಕಾರ್ಡ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ. Counsel for the appellant prays for time. The appeal is listed for the 5th time for compliance of office objections. I do not find any reason to adjourn the matter, however, for final opportunity was come. It is posted finally. You have to produce it and comply office objections. Next.
Serial number 38, Harish Bandari.
Done.
Serial number 39, government advocate.
My lord, in this case, my lord, we could not find the correct address, my lord. My only request is that, my lord, he is the permanent resident of Thane, Maharashtra, my lord. BW may be ordered.
ಏನಾಗಿದೆ ಮೊದಲು ಇದಾಗಿದ್ದು address ಇದು summons.
Not found in that address.
Hello. Hello. Then the HCP submits that the respondent is the resident of Thane, Maharashtra. The notice sent, the summons sent by this court is returned answered as not found in the address. Therefore, prays for issuance of NBW to secure the presence of the respondent. In view of the above, issue NBW against respondent through Yaru,
Through Dakshin Kannada, Commissioner of Police,
jurisdictional police,
Bangalore.
the direction to execute the same. In case of execution of the NBW, accused is ordered to be produced before the jurisdictional magistrate.
Please, ma'am.
And to who shall report the same to this court. Yes, produce before the jurisdictional magistrate and report the same to this court.
Obliged.
Yes.
Serial number 40.
Format ಇದೆ ನೋಡಿ ಮೊದಲು ಮಾಡ್ತಾ ಇದ್ದಲ್ಲ. Directed to remand the relevant parties.
40 Jairamaya.
Paid.
Paid.
Process paid.
Idea.
It's under,
Counsel for the appellant submits that he has paid the PF.
it may be connected to criminal appeal number 550 for same party, my lord.
Respondent office to verify if PF is paid, issue notice.
Number.
Then counsel for the appellant submits that.
Number.
Criminal appeal number.
Criminal appeal number 554 of 2020. It's same part, between same parties, my, in respect of two checks.
Connected with the present appeal. Office is directed to verify.
And number.
List both the cases together. Yes.
Serial number 41 Somshekara AN.
Counsel for the appellant is absent, no representation, even when the matter is passed over twice and called again at 3:12 PM. PF for issuance of notice to respondent is not paid.
Same parties.
The appeal is of the year 2020. It appears the appellant is not interested in prosecuting the appeal. However, to offer final opportunity is done. Next.
Serial number 42 Prasanna Kumar P. Needful is done, ma'am.
Needful has been done.
Done. Yes.
Serial number 43 Government advocate.
My lord, in this case, my lord, I have obtained the correct address, my lord, and we permitted.
Lord,
permission
HCP
correct
filed
address.
What is that?
Correct address, my lord. I am along
Furnished.
with a memo.
Yes.
I am furnishing the correct address. my lord.
File the memo furnishing the correct address of the respondent.
Respond number 2, my lord.
Respondent number 2.
Respect of respond number 1, my lord, it is Pune, Maharashtra, my lord, the address is, we have not yet received the police report.
Respondent number 2. Office issue notice to respondent number 2 is to his correct address. Next. HCP prays for time to furnish correct address of respondent number 1.
No, my lord, we had furnished the address, my lord. Notice was issued. It has not, the police have not
Onset of
filed the
report
report
with
with respect
regard
of the
to
service of notice.
Await report.
Please, my lord.
ನೀವೇ ಕೇಳ್ಬೇಕು ಮತ್ತೆ ಅವರಿಗೆ ಏನಾಯ್ತು.
I will follow it up.
Yes.
44.
Notice of respondent.
Serial number 44 Rama Devi. Final.
Counsel for the appellant absent ಅದೆಲ್ಲ ಹಾಕೊಳ್ಳಿ. Finally, order sheet dated so and so reads under ಅದೆಲ್ಲ ಹಾಕಿ dismissed. Next.
45 Ram Prasad SN.
Needful has been done.
Done.
Yes, ma'am, done.
Needful done. Next.
Serial number 47 Krishna Rao.
Counsel for the appellant is absent, no representation. Yes, Tom. Yes.
List two, serial number two. Amit,
My lord.
తీసుకొండి.
My lord, in this case, my lord, the warrant was forwarded to Under Secretary Ministry of Home Affairs, New Delhi, my lord. Because the respondent is, the address is Thailand. my lord. So the warrant was forwarded to them, my lord. It was not given to state policemen.
It was
It is
given to
by the intelligence officer directly. DRI, my lord, is the appellant.
Under Secretary Legal.
The thing, my lord, the respondent has been represented through an advocate, it seems, my lord.
ಎಲ್ಲಿ
Manjunath G ಅಂತ ತೋರಿಸಿದೆ ಪಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ.
ಮಂಜುನಾಥ್ ಜಿ ಅಂತ ಇದೆ, absent ಇದ್ದಾರೆ.
It has been shown his name.
Bail bond is not furnished.
Not furnished the bail bond.
That is not furnished.
ಇಲ್ಲ, ಎಲ್ಲಿ ಬೇಲ್ ಆರ್ಡರ್ ಆಗಿದೆ ಎಲ್ಲಿ?
On 31/10/2023, my lord, bailable warrant was executed and he was supposed to furnish the bail bond and with surety, my lord. They have not done that.
ಬೇಲಬಲ್ ವಾರೆಂಟ್ ಇದ್ರೆ ಪರ್ಫಿಟ್ ಆಗಿದೆ.
They have appeared and represented, I think, my lord. I am not aware of the earlier.
So
The appellant is also
for the
absent.
appellant and respondent are absent, no representation. As per order dated 30/10/2023, respondent was directed to appear before trial court and execute the bail bond for rupees 2 lakh with one surety for like sum. Till date, it is not reported as to whether there is compliance of said order. Sole respondent, sole respondent.
Yes, my lord.
ಏನಾಗಿದೆ ಇದಾಗಿದೆ, ಏನಾಗಿದೆ ಪೊಲೀಸ್ ರಿಪೋರ್ಟ್ ಬಂದಿಲ್ಲ ಅಂತ ಎಲ್ಲಿಗೆ ಕಳಿಸಿರೋದು ಅದನ್ನೇ ನಾವು ತೋರಿಸಿದ್ದೇವೆ. ಇದರಲ್ಲಿ ಇದೆಯಾ? ಇದು ಓಕೆ.
I think the respondent is the resident of Thailand.
When the HCP submits that the respondent is the resident of Thailand.
We have not received any
Unbailable
warrant.
was issued against the respondent. Through the Undersecretary, Department of Legal, Minister of Home Affairs, New Delhi. The report is still awaited regarding execution of the NBW. Office is directed to issue reminder. Yes. Reminder of keep ಮಾಡ್ಲಿಕ್ಕೆ ನೋಡೋಣ. ಇಲ್ಲಾಂದ್ರೆ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಮತ್ತೆ ಯಾರನ್ನ ಕರೆಸ್ಬೇಕು.
Lord, the appellant itself is an investigating agency, my lord.
Intelligence officer.
Directorate of Revenue Intelligence, my lord. They themselves are the investigating agency.
Appellant is directed to verify about execution or otherwise of the NBW. Yes, next.
Serial number 5, Sachin BS.
My lord, in this case, my lord, we have not received
The
any
appellant.
warrant, my lord. I think warrant was not sent to the jurisdictional police, my lord. It was sent, the order copy was only sent to the court, my lord. Kindly reissue the warrant, my lord, will.
Lords, in this case, my lords, I undertake to file wakalat, my lords. The reason
For
being,
whom?
for the appellant, lords, the reason, my lords, earlier, my lords, initially it was filed in the senior counsel's name, my lords. After his designation, his old colleague's name has been, my lords. Now he's no more,
Sachin BS,
he's no more a part of the associate. That is the reason.
he is not representing. You are filing wakalat.
I'll file.
So and so undertakes to file wakalat for the appellant and submits that the counsel Sachin BS He is no more representing the appellant. He is no longer represents the appellant. Submission is placed on record. Office is directed to delete the name of so-and-so and show the name of so-and-so. ಏನಾಗಿದೆ NBW is sent to the trial court.
Yes, my lord.
They colleague.
Copy of the order was sent to the trial court, magistrate court, my lord. The warrant was not sent to the jurisdiction.
Reissue NBW to the respondent, against the respondent through the jurisdictional police. In case of execution of NBW, otherwise then produced before the jurisdictional magistrate.
Let the appellant also cooperate for the execution.
The reissue NBW through the jurisdictional police. Appellant is directed to cooperate with the police for due execution of NBW. Appellant,
Please.
you have to assist. Yes,
Obliged.
next.
Serial number 10, G.A. Srikante Gowda.
I filed the memo, Your Lordship.
Who are you?
I am the GPA holder
Of
of the respondent. The legal counsel has retired. I tried filing the NOC. They want me to file because I'd like to appear in person. I'd like to seek the permission of this court. So they asked me to file an application with the NOC, which I will be doing in the next day or two.
Your name is Rashmi,
Rashmi Munikempanna.
Miss Rashmi Munikempanna. Said to be the GPA holder of the respondent. He is present before the court in person and filed a memo reporting the death of the appellant.
Yes, yes. Your Lordship.
Appellant on 21/8/2023. The death certificate is also enclosed with the memo. Yes,
I'll
abated.
take steps, ma'am.
Huh?
I'll take steps, ma'am, within a week.
Steps ತಗೊಳ್ತಿರೋ. Then counsel for the appellant, praise for time. 2023 na,
Yes, Your Lordship.
the appeal is already abated. However, and counsel for the appellant, praise for time to take steps to include the legal representatives of the deceased appellant. Please come. No further date will be given. It is already abated.
Please, madam,
Yes.
I'll call an update, recalling update.
Yes.
What's up?
Serial number 23, R. Srinivas, Melan Sebastian. Morning also there was no representative.
Good. Very nice. Counsel for the appellant is absent, no representation. Appeal is of the year 2013. I do not find any reason to adjourn the matter, however, to offer final opportunity. Well, ಸ್ವಲ್ಪ first time ಬಂದಿದ್ದೆಲ್ಲ ಸ್ವಲ್ಪ longer date ಸ್ವಲ್ಪ longer date. Finally, ಮತ್ತೆ 2-3 ಸಲ ಬಂದಿದ್ದು short date. Next.
Serial number 29, Nagaraj B.
PCR await ಇದೆ.
Await TCR.
Yes, madam. Okay.
Let it come ನೋಡಿ ಯಾವಾಗ ಕಾಲ
ಸ್ವಲ್ಪ information ಕಳ್ಸಿದ್ರಿ.
ಬರ್ಲಿ.
Yes, ma'am.
TCR ಬರ್ಲಿ.
Okay.
List after receipt of TCR.
Yes, madam.
ಆಯ್ತು. ಬೇಗ ಮುಗಿತು. ಬೇಗ ಮುಗಿದ ಬೇಯ್ತದೆ. ಜಾಸ್ತಿ ಅನುಕೂಲ ಅದು 6 ಗಂಟೆವರೆಗೆ ಹೋಗುತ್ತೆ. ನೋಡೋಣ.